of the Civilian Police Review Board. Thank you all for your patience. I'm sorry for the delay. I'm going to start this. First, I'm going to call this meeting to order at 9:22 a.m. And I'm going to begin with a roll call. Brandon Brown here. Billy Sharp here. Diana Saganovich has an excused absence. David Gatton here. Shanoa Miller here. Edwin Moore here. Glenn Parker III here. Waverly Willis here. Okay. We're going to start. First, I am going to modify the agenda a bit because we had an update. As of yesterday, I was reappointed to the board for a second term. And so with that, we are going to move forward with our kind of regularly scheduled elections for chair and vice chair. Per the charter, every year we have to elect a chair and a vice chair. And so we will start with the position of chair. Generally, the way that this will work is I will open the floor for nominations. If anybody would like to make a nomination at that point, please do so. You are also allowed to nominate yourself. If we have multiple nominations, or if we have nominations for multiple people, we will take a vote in the order that the nominations came in. It won't be like there's no. It'll just be an aye or nay vote the way we normally do. If any one person passes, that person will essentially will win that role. Does that make sense? That might be a little clunky in the way I just said that. Remember that? Yeah, sorry, roll call vote. Yes, I just meant not a ballot like paper where we're like signing one person's name or another person's name. It's gonna say, so if person one is nominated and then person two is nominated, we'll take a motion. We'll make a motion for person one. Everyone will vote, roll call, and then if that motion fails, then we will move to person two, just in the order of the nominations. Is that appropriate?
I mean, we have ballots coming if you want to do that instead.
Yep. We can do ballots? Yeah. You guys, I don't care. How do you guys want to do it? You want to do ballots? I don't know how opinionated you guys are. Okay. Okay, well, we can do ballots then.
Since they printed them out.
Oh, okay, well, we can do ballots. Sorry, I thought we were going to do ballots. Okay. So, yeah, we can do ballots. So you said Katie is bringing them down?
Yeah.
Okay, I will speak slower. Okay. So with that, we will start with the position of chair, and I will open the floor for.
You got a hand up.
Oh, go ahead. I'm sorry.
I have to who?
He had to say that.
Oh, I'm sorry, Dave. Go ahead.
I'm sorry.
Yeah, no, go ahead.
I was jumping the gun.
No,
All right.
was your hand up for a nomination?
Yeah.
Oh, okay. So I will now open for nominations. Dave.
I'm not interested. No. I'd like to nominate Brandon Brown for a position of chair. In doing so, I think he's performed admirably. We've had a significant change on his watch in terms of personnel in the OPS office that he's managed smoothly. He's managed the meetings well. I think the work that's being done here speaks for itself in terms of quality of cases that we're getting, how many are being closed, and how well the meetings are run. So should he accept, that's my nomination.
All right. Thank you for those kind words. I do accept the nomination. Just.
Don't you need a second?
Do I need a second? This is the first that I've conducted of these, so.
Do I need a second?
Do I need a second on the nomination? Okay, I would now entertain a second for the nomination.
Chair, if I might, I offer the second on that nomination for the same reasons that Dave Gatton gave. I would like to share in those comments that having you in the position as chair through what we've been through, I think you operated excellently and have no problems that you'll do the same moving forward. So I second that nomination.
Okay, thank you again for those kind words. Now that the that the nomination has been seconded, I will accept the nomination, and I will also now open. I mean, continue. The nominations are still open. Would anyone like to make any additional nominations for chair? Okay, hearing none. I will now entertain a motion to elect the chair.
I thought we were doing that.
Oh, we're doing.
I thought we were doing that.
Well, we don't really need a ballot because there's only one person.
Oh, never mind. It's fine.
Yeah, so yeah, we'll do the roll call.
Gotcha.
But I need a motion, and I don't want to make the motion because
Yeah, I'd like to make a motion that we move forward with the one nomination for a vote.
Second.
okay, we have a motion to move forward with the one nomination for Brandon Brown as chair. It has been properly seconded. So I will now go through the roll call. Brandon Brown, yes. Billy Sharp,
Yes.
Dave Gatton,
Yes.
Shanoa Miller,
Yes.
Ed Moore,
Yes.
Glenn Parker III,
Yes.
Waverly Willis.
Yes.
All right, that motion carries. And so I will continue as chair. Thank you. I appreciate it. Now, we can now move forward with our vice chair position. And I will now, well, I guess before I open it, I will say, for this vice chair position, I do think it's worth noting that generally over the past few years, the chair has served for 2 consecutive one-year terms. And the second of those terms, which I am now in, usually the vice chair, the idea is that the vice chair kind of serves with the chair with the expectation that they may want to run for chair themselves in the subsequent year. So I would like, our board members to kind of keep that in mind as well. Obviously, that's not like in stone or anything, but I did want to note that is the idea, is that we use this year to kind of get a vice chair ready to potentially become chair in an effort to have a smooth transfer of positions. Okay, so with that rambling done, and now having our ballots, I will now open the floor for nominations for vice chair.
I'd like to nominate myself for vice chair.
All right, we have a nomination for Waverly Willis. Can I get a second?
A second.
All right, we have a second. Any other nominations before we go to the ballot, or before we just cast a vote?
I'll nominate myself for vice chair.
We have another nomination for Shanoa Miller for vice chair. Can I get a second?
I'll second.
Seconded by Member Gatton. Do we have any other nominations for vice chair? Okay, hearing none, we have 2 candidates for vice chair, Shanoa Miller and Waverly Willis. And so with that, we will do a ballot vote. And so can we get those?
You want to be consistent. I know.
Yeah.
I know.
To
Yeah,
be
you
consistent.
wanna be consistent for both.
Yeah.
That way it
I mean,
happens.
well, the difference would be you didn't have 2 people running.
So my question regarding this will be, will we roll call vote for both candidates, and what if both get a majority of the votes? How do we handle that? Or
So can we
do a roll call vote where we choose one or the other?
I think choose one.
Okay, so we can do a roll call vote, and when I call your name, you will make your selection for either Shanoa or for Waverly,
Yeah.
and we can do that.
Yes.
No, just a point of clarification, though. I would say the ballots to me would be appropriate in this case, again, because there's two people running instead of,
And it's
in,
different from
in the chair's position, there was only one. So a roll call vote would have, you
I
know,
agree.
I mean, that's just.
I mean, I would agree with that as well, but
So. For consistency's sake, technically we could do the chair vote again. You fill out that ballot as well, just to make sure they're valid for both. You know what I'm saying, so they're both done by ballot. But it doesn't really matter.
is it one sheet of paper with both positions on it?
No.
There's a separate one for chair.
Okay, here we go. So we're just gonna do the vice chair by ballot, it's fine. We can do that. It's fine, so we can be like two seconds.
This is not this complicated, y'all. We've slayed much bigger beasts.
So good.
Okay, so are we handing out ballots?
Yes,
Yeah.
Okay.
so we got to give her a second. So do we want to give them a chance to speak to why they want to be? This would be
Okay,
great.
yes, so, all right, well, while Dahlia is preparing that, do either of our candidates want to make any sort of statement about why you would like to be vice chair, since we're killing a little bit of time anyway?
And then the topic.
Sure,
Yeah,
I'd like to say a few words.
Sure. And Willis?
I'm member Waverly Willis. I am a Cleveland resident. I own 3 businesses here in Cleveland, and the foundation of my business is rooted in community service. I am the owner of the largest minority-owned barbershop chain in the state of Ohio. And again, we've done so much community service that is really how my business name and my name got out. That's how I got on the board. I am definitely call myself a servant leader. I'm new to the board, but I'm passionate about helping Cleveland out and doing what's right, just, and fair for the citizens of Cleveland. So I would appreciate your vote for vice chair of the CPRB.
All right, thank you for that. Member Miller, would you also like to make a statement?
Hi, everyone. My name is Shanoa Miller. I've been serving on the board, I believe, since 2021. I joined as a youth representative representing the 5th District, the Glenville neighborhood. I am a lifelong resident of the city of Cleveland. I am a proud Glenville resident. I attended Cleveland State for my Bachelor's of Arts in Urban and Regional Studies with a concentration in public management. Public focus has been a part of me since I was in high school, focused on the Glenville Uprising, and then going into also working with working with the Cleveland Police Foundation, focused on introducing youth into public safety careers. Oh. So public safety has been my focus, being very, very young, representing youth on this board, and also the relationship with youth with our police officers. Being on this board, I have learned so much from various leaders within City Hall and amongst the people that I'm sitting next to. And I think that has well equipped me to serve within this role now within my 2nd term on the board. So thank you so much for your time.
All right, thank you for that statement. Does everyone have their ballots in front of them? Okay, so just looking at this, you will cast a ballot by, I guess, marking either Member Miller or Member Willis. I know that all of our names are listed on here, but please just mark either with X or initials or whatever. Just make it very clear who you're voting for. Then once you do that, you can kind of fold it in half and we'll pass it down to Dahlia. Or should they pass it to me? She'll pass it to me.
Question.
We have a question. If you want to abstain, there are also lines for abstentions as well.
Is the law department's roster updated?
That's a good question.
Is the law department's roster updated?
We have somebody on the list that's not a board member.
The list I have,
Sure.
I didn't make the ballot, so.
That's why I'm asking, is the law department list updated?
Our vote is updated, yes.
Okay.
Well, I'm gonna assume nobody's gonna vote for a person
Well,
who's not
yeah, that would be.
on the board. Vote mine up like I'm sorry.
Right, like you don't know.
Okay, so by majority vote, Shanoa Miller, is gonna be our next vice chair. So congratulations, Member Miller. Dahlia, do you want these for
Yeah.
like record's sake? We should probably keep them since we did them.
Everyone's satisfied.
Yep.
Yeah.
Okay. It is 9:38. Super efficient with that, guys. Okay. Now that we have a chair and vice chair, we can proceed with our meeting. All right, so we will now start with the approval of our minutes. So does anyone have any questions, comments, or concerns about the June 11th meeting minutes? Hearing none, would anyone, can someone make a motion to accept the minutes?
Motion to accept the minutes for June, is it June 11th? I said July, I'm so sorry.
We have a motion on the floor. We have a motion on the floor to approve the June 11th minutes.
Second.
We have a second from Member Willis. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. Okay. We will now move into public comment. Is there anyone who's here for public comment specifically? Are you here for public comment or are you here specifically for a case?
Oh, yeah.
Well, technically there's a difference. So if you want to speak specifically to a case that you have, we'll have a time period for that as well. But if there's something separate from that that you would like to speak on, you also get some time for that as well. So it's up to you to.
Now and then, this pertaining to the case.
We'll do your case first.
Yeah. So if you're here for a case, we've already noted that, and we will move that case to the front of our presentations. Yeah. Yep. No problem. Okay. Anybody else? No. Okay. Okay. We have a officer commendation on our agenda that I definitely want to get to because I didn't get to it in the last meeting, and I really like being able to take the opportunity to read these commendations on the record in our public meetings because I think it's important, even though obviously we're a body that's charged with holding our officers accountable when there are issues. We also, when the opportunity presents itself, we want to know when our officers are doing exceptional jobs. So with that, let me see if I can get this to open. All right, well, here we go. Okay. So this note or commendation came into us from a civilian uh, who really had a great interaction with one of our officers. This is Officer Martinez, badge number 1346. And under the description, they put, this is a compliment. Thank you, Officer Martinez, and your colleagues. And they stated that my nonverbal autistic cousin went missing and our family was frantic. The Cleveland police officers arrived quickly and were prepared to help us. Fortunately, the incident could have had a much different outcome, but fortunately, the officers asked all the right questions and acted professionally. We are truly grateful for their prompt response and dedication to serving the community. So again, this was out of the 4th District. And this is Officer Martinez, badge number 1346 was identified. And I believe there were some other officers there as well. So again, to both Officer Martinez as well as the 4th District, we did want to read this commendation out to let people know that, hey, our officers by and large are doing great work. And I really like taking the opportunity to be able to read these that we get in. And, I also encourage other members of the community, if you have a positive experience with anyone and with the Division of Police, feel free to either call in to our Office of Professional Standards or send in a written report and mention that. And we will make sure that we mention that during our meetings. So with that, we will now move into our presentation of investigations with any citizens or CDP employees present. And I understand that we have a couple. So I'll turn that over to
Okay,
Mr.
to
Manager.
begin with, I'd like to draw the board's attention to the agenda appeals, case number 2. We have a citizen present. It's case number 2026-0084. The complainant is Julie Jones Fuentes, and the investigator will be Boker.
Yeah, okay. So before we start, we're going to have our senior investigator, Mr. Boker. He's going to kind of give us a general overview of this case and kind of what's going on here and where we are procedurally. And then you will be afforded some time to come and talk to us and just kind of let us know anything that you think we should consider as it relates to the case. And then from there, we will ask you any questions that we may have. And then after that, we will deliberate and kind of make our decision on the case. So we'll start with Mr. Boker, and then we'll call you up to the podium.
This case is actually an appeal of an administrative that the office did. We did not complete an investigation beyond determining that it was outside the scope of our authorities to investigate. The complainant is a school crossing guard, and as such is a member of CDP. She's employed by CDP. Section 101 states OPS was established for the purpose of investigating non-criminal complaints filed by the public against sworn and non-sworn CDP employees. On its face, this language identifies as the source of the complaint as public. In ordinary usage, an employee of an organization is generally not considered part of the public when acting in their official capacity. If the individual is reporting another officer's misconduct as part of their job duties, that is typically an internal complaint or an administrative report, not a complaint from the public. There is actually a GPO that outlines that CD employees are supposed to file internal reporting procedures, which is GPO 1.07.05. This complainant has actually filed a case in 2025, which was dismissed for similar reasons. However, it was dismissed, but it was also investigated by Internal Affairs. They completed an investigation. This particular complaint was filed this year and it has been referred to the school crossing guard supervisor for their action. I would note that it's my understanding the law department has determined that this complaint is outside of OPS's jurisdiction for the rationale that I indicated that it's a internal complaint and there's a procedure for handling that. I would also note that section 305 of the OPS manual says that while OPS must not deter the CDP or outside non-federal law enforcement authorities in completing its investigation, OPS is not required to duplicate investigative efforts if they determine the material generated in the CTP investigation is helpful. So in this case, the complaint is an internal, from an internal employee, internal complaint, and it has been referred internally for investigation. And that concludes the presentation.
Yeah, thank you for that. Does anybody have any questions for our investigator? I mean, yeah. Okay, so I want to make sure that I'm clear about this. So this was an internal complaint made by another CDP employee against a CDP employee. And
And when I say it was filed with OPS, it was determined it should have followed the internal process under the GPO that I mentioned. And that consistent with the advice that we received from the law department, that internal employees filing complaints against other employees are supposed to go
we're
internal.
supposed to go through IA. Oh, okay.
And that's not to say that we didn't make sure that someone was investigating it. It's been referred, we've had communication with, well, we also had communication with IA who indicated the previous status on the other case and indicated that this complaint had been referred to the school crossing guard supervisor.
Okay. Ms. Jones Fuentes, you can approach the podium. And can you?
How much time she has to talk?
One second. First, can you, if you tap the front of the mic, it'll turn green? That light? Yep.
Okay.
And so you will have 4 minutes to kind of, again, tell us anything that you think that we should consider. And then we'll ask you some questions. I do have a few questions, but I'll let you kind of tell us what you want to tell us, and then we'll
Okay.
go from there.
Okay, thank you. I'm not a public speaker, so I apologize in advance. My name is Julie Fuentes. I have been working as a school crossing guard for almost 11 years. I'd like to provide an update on the complaint I filed May 22nd, as well as offer a suggestion. On July 28th, Captain Michael Butler announced at the annual school crossing guard meeting just a couple weeks ago, the city will be instituting the software app called Workday with geofencing. How this app works: when the guard opens the Workday mobile app on their phone to start their shift, the app checks their location. If the guard is inside the digital boundary, the app allows them to punch in. If the guard is far away, the app blocks the punch. This technology confirms the guard arrived at their location on time and for the duration. Second, I understand the CPRB has the authority to recommend administrative resolutions and policy changes. So this is what I want to say. The Plain Press ran a story in their June issue about the Cleveland Police Consent Decree, a report analysis titled Community Engagement and Building Trust. And I have that newspaper, by the way. It outlined 18 paragraphs of goals examined by the monitoring team. The city of Cleveland did not reach substantial and effective compliance for any of the 17 out of the 18 goals examined. Remember, the crossing guard unit, which its main purpose is to protect the city's children, is supervised by the Bureau of Community Relations. Therefore, I offer this suggestion. Please consider recommending the hiring or appointing a civilian liaison to the crossing guard unit, an individual who holds a bachelor's degree in business administration with experience in managing large groups of employees. This new position would oversee recruitment, retention, safety and services, build relationships with students, schools, parents, and crossing guards. For a long-term continuity, this individual would create a blueprint for future police officers who transfers into the unit as current unit staff retire. For accountability issues, This independent civilian can objectively monitor fair oversight of crossing guards, preventing leniency and favoritism that often occurs when those in the police unit supervise their former colleagues or now employed as crossing guards. And that's common, by the way. I have worked for many years in the city of Cleveland as a registered nurse, both on the east side and the west side, who performs home visits to the very ill. Many patients have been children who have sustained traumatic brain injuries, usually because of accidents. A once normal and vibrant child now reduced to a lifelong ventilator, tracheostomy, feeding tube, diapers, bed sores, and the inability to communicate their needs. The public may read or see a tragic accident that occurs, but very few people see the aftermath of the devastation a car accident or pedestrian accident truly has on the victim and their families. In medicine, we practice preventative care. Why are we not doing the same with protecting all city children? There will be 29 less schools in Cleveland this year. This mostly means more children in buildings and more pedestrian traffic. This increases a child's risk for an injury or fatality walking to and from school. So again, I ask the panel to please consider recommending a civilian liaison to the school crossing guard unit. And thank you for your time, by the way.
All right, thank you for that statement.
Thank you.
First of all, I want to start by saying thank you for your service to the community, both in your capacity as a nurse and as a crossing guard for all of these years. The protection of our children can never be overstated. So I really do appreciate that. And I appreciate your civic engagement as well to both make these complaints and to come here and speak with us, because I know it's taking time out of your day for whatever else you would be doing besides being here. So that's not lost on me. And I don't want you to think that we don't think that this is an important issue, because it is. We are kind of very specifically charged with what we are supposed to be doing as far as holding officers accountable when civilians make complaints, right? And that's a little bit about what Mr. Boker spoke about, right? There's a different process for disciplinary measures. As far as the specific statement that you made today and the ask for us to push for a civilian liaison to the crossing guard unit, I think that's an excellent idea. And so what you would have the ability to do as the board is recommend that to both the chief of police and the Cleveland the Community Policing Commission, the CPC. And I would actually encourage you to speak with them as well and attend their meetings. Their meetings are in the evening, so they're a little bit, I don't know if that's better or worse for you. Oh, okay. But even if you don't, right, our recommendation would still go to them, and we have mechanisms in place now where we try to follow up with them about what we have recommended. And so I would certainly be in favor of that. I'm going to go out on a limb and say the board is probably going to be in favor of making that recommendation to them for a policy change. They're in charge of doing that. Obviously, if you showed up there and you even just read what you read us to them, that could also be very persuasive. But I understand if you work in the evening and it's difficult, that's okay. We don't mind pushing this agenda for you in that way. As it relates to this case, I want to be clear that it doesn't necessarily change that we can't really impose any discipline here, because that goes through IA, because it's essentially an officer making a complaint against another officer. But I did want to let you know that it's not that we're kind of turning a blind eye or ear to the issue, particularly because you came here today and made a very specific policy recommendation, which is to be commended. So I don't know if any other board members have any other thoughts, opinions, questions, or comments on this, but I'll probably make a motion if not.
I had a question.
Yeah.
On topic and off topic. So if a civilian made a complaint against a crossing guard, that comes to us?
Yes, because the crossing guard is employed by CDP. So any CDP employee, sworn or non-sworn, right, falls under our jurisdiction. This is kind of what we were just talking about the bailiffs. Yeah.
I did not know that.
Well, the same way where, like the dispatchers, they fall under us as well. So it's not just police officers, right? Yes. Yeah. Anybody who's employed by CDP, if there's a civilian made complaint. And I think maybe there's some kind of gray area about whether or not an officer acting in their civilian capacity may be able to send us a complaint. I don't know if that necessarily is present here, but I could see that being a potential discussion down the road. But yeah, any other questions, comments, concerns, statements? Okay, with that, I am going to move that we make that OPS helps us craft a policy recommendation that a civilian liaison to the crossing guard unit be created, and that policy recommendation be sent over to the chief of police in office, as well as the Community Policing Commission. Can I get a second?
Second.
Seconded by Member Sharp. Those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. And so with that, we are going to work with Office of Professional Standards. Usually that means we'll craft a letter and we'll send that out to both the chief and the CPC, which will hopefully spark the conversation that will allow us to come together and kind of deal with that logistics, right? Because there are some logistics to go through. If you don't mind, I would love to have you continue to be a part of the conversation. And so can we make sure, Jeff, that we include Ms. Jones-Fuentes on in this conversation because she's been the catalyst. And so we'd love to have your experience on this to help.
I'm sorry.
No, yeah.
I think that's important. I think that's what was missing, which is why you need a liaison.
Mhm.
It's when you have a us versus them mentality.
Yep.
But this is what happens. So no, this is exactly what we need to do. So competition. Thank you.
Good. So we will be in contact with you and we'll be able to continue this conversation. And once again, thank you so much. I appreciate it. Hope you also know sometimes, as we say up here, if you volunteer an idea, sometimes you volunteer for the position too. So, so keep that in mind. But thank you very much.
I appreciate it.
Yep. Have a good one. I don't know if we need a motion on the case, but in case we do, I'm going to move that we uphold the OPS administrator's dismissal of case number 2026-0084.
Second.
Seconded by Member Sharp. All those in favor say aye.
Aye.
Any opposed? Any abstentions? That motion carries. Okay. So with that, I think do we have anybody else? We have somebody else, right? Okay. We can move on to that case.
So in the interest of citizens that are present, I'd like to direct you to the new cases, page 13, item 13. That'll be case number 2025-0019. Complainant is Christina O'Neill, and investigator Lampkin will be presenting.
Thank you. Please forgive me. I have a dental situation, so if I sound strange. Okay, this is OPS case number 2025-0019. The initial allegation is A, lack of service, insufficient service. The subject officer is Patrol Officer Daniel Sherlock, badge number 1569. And on August 3rd, 2021, while leaving her 3-year-old child's chemotherapy appointment and waiting at the red light on 93rd and Kinsman, Christina O'Neill alleges that Patrol Officer Sherlock allowed the at-fault driver of this accident to leave the scene of the accident without knowledge of the fact. Ms. O'Neill and her 3-year-old child were involved in a 3-car traffic accident at 93rd and Kinsman, where the second driver, Mr. Jones, was pushed underneath Ms. O'Neill's vehicle. After the accident, Mr. Jones pulled his vehicle from underneath Mrs. O'Neill's vehicle, drove across the street, and parked. Upon scene, Patrol Officer Sherlock arrived and after a conversation with Mr. Jones, allowed him and his passenger to leave the scene. Feeling that the accident was not a quote-unquote hit and skip, Patrol Officer Sherlock did not inform Ms. O'Neill or her family that he had allowed Mr. Jones to leave the scene. Ms. O'Neill was aware that Mr. Jones parked his vehicle across the street and informed Patrol Officer Sherlock of her inability to acquire the tags and the plate number of Mr. Jones's vehicle. And while knowledgeable that he allowed Mr. Jones to leave the scene, Patrol Officer Sherlock acknowledged the difficulty of reading tags inside the vehicle, thus engaging in a conversation with Ms. O'Neill. He later stated in the OPS interview that after speaking with Ms. O'Neill, he realized that he let Mr. Jones leave the scene too soon and admitted he should have done a better job. Although Patrol Officer Sherlock identified the accident as non-fatal in his incident report, EMS was dispatched due to Ms. O'Neill's child having just recently received chemotherapy treatment. Ms. O'Neill's copy of the accident report included detailed information about the other driver, but her requests for records were unsuccessful due to the file retention policies. Patrol Officer Sherlock admitted not giving full attention to his duties while allowing Mr. Jones to leave the scene without gathering complete statements from the parties involved and failed to inform Ms. O'Neill that he authorized Mr. Jones to leave the scene, leaving her and her family unaware that Mr. Jones had departed. Additionally, Patrol Officer Sherlock did not complete a thorough police traffic accident report. Based on the above analysis, OPS recommends a finding of sustain based on the preponderance of evidence which supports a finding that the alleged conduct occurred and the officer's actions were inconsistent with law or Cleveland Division of Police General Police Orders, Training, and Procedures. That ends this report. Do I have any questions or concerns?
All right, thank you for that presentation.
You're welcome.
I do have a question. So I just want to make it clear. So this incident occurred back in 2021, but we got the complaint on February 10th of this year or of last year.
Last year.
Okay. All right. And does anybody else have any other questions before we bring Ms. O'Neill up? Okay. Hearing none. Ms. O'Neill? I will, as you approach the podium, I will let you know that we have, you'll be allowed for 4 minutes, again, to just explain anything that you think would be pertinent to us evaluating this case and making any sort of deliberations. If we have any questions after those 4 minutes or after you're done making your statement, we will ask you those. And then from there, I will ask you to take a seat and then we will deliberate about the case. So with that, whenever you are ready.
I know it's been a while that this had happened. Discussing it right now is kind of hard because she did pass away.
Very hard. Sorry to hear that. It's okay. Take your time.
I just felt like that I was failed because of what happened. I've never been in a situation like this before. I've never been in a car accident. I did mostly all of the footwork. I did get the information, the vehicle tag, because it was literally on the back of the car. I had pictures. I even tried to file the case in Shaker Heights where the car was registered to. And because they didn't show up, they threw it out. The young man that was driving the vehicle, he did not give up his information. He gave his information up to the third party vehicle because he thought that he was going to get some money out of it. So that's how we ended up getting his information. I did give Hidden Skip and other detectives that I talked to on the phone where to locate the owner, where their job was located. And basically nothing happened. I called Hidden Skip because I figured it was a hidden skip since there was no ticket or anything given to the person that hit. They told me they were 2 years behind, which is past the statute of limitations. So that's why we're here today.
Okay, thank you for that statement, and thank you for coming here. As I stated earlier, I know that given the time of our meetings, that people kind of take time out of their day to come and speak with us, and that's not lost on us. And I appreciate you taking the time. My condolences on your loss as well. So, does anyone have any further questions for Ms. O'Neill? I have one. So you made the complaint to our office in 2025?
No, I actually made it a little earlier, but I kept getting the run around on who to call and who to talk to.
Okay.
And between that time, you know, I was still dealing with my daughter at the same time. She was just 3 years old. So I was dealing with that at the same time. I wasn't even like trying to take care of my own body because I was dealing with her. That's when I got a call. I talked to, I believe it was the chief of police maybe, and they told me to file this complaint, which I ended up going to Miss Tammy Lampkin. So after that, I didn't hear anything else, and now here we are today.
Do you remember, I guess, what year it would have been when you first started trying to file a complaint? I know you said you got to run around for a little while. The date we have is like February 25. Was it 24, 23?
Actually, when the accident happened, I was told to continue to call to check. And I ended up calling in January the following year. And then someone told me, oh, your case was, you know, completed back in November. But they told me they were 2 years behind. So I'd never, you know, got a call or anything about that. I was told that the report just kept getting sent back because it wasn't correct.
And this was the report from CDP, like the incident report and the traffic OH1 and those documents. Okay, and those are separate from our complaint process, but okay. So my thought process right now is I'm trying to kind of build a timeline because one of the restrictions for the collective bargaining agreement is that any complaint that is brought against an officer, they have to be notified of that within 6 months of the incident that occurred in order for them to be disciplined.
Right.
That doesn't mean that it won't be investigated. Obviously, this has been fully investigated, and we can still make a finding. Is that right? I want to make sure that's right. We can still make a finding of sustain. We just can't discipline.
Yes.
Right. So I do want you to know that we can still make a finding here, but unfortunately, given the time that passed between the incident and when the complaint came in, we won't necessarily be able to make any sort of impose any discipline against the officer. What I will tell you is that it seemed to me from the interview with the officer and Investigator Lampkin, I don't know if you want to speak to this, but it seemed like the officer understood that his actions were not acceptable, and kind of readily admitted that he shouldn't have let the other driver go in that moment. It's clear from the report that he didn't collect all the evidence that he should have. And so what that hopefully means to me is that this officer is going to take this experience and has taken this experience moving forward to perform better. I know that that's not, always a complete outcome that you may want here. But unfortunately, given, what we have in front of us, that is for the most that we could do here is, we would have a sustained finding here, or we could have a sustained finding here if the board votes that way. But per the rules, we wouldn't be able to impose any discipline. Go ahead.
So when you talked about your attempts in the beginning to lodge the complaint with the Office of Professional Standards, you said you were getting some runaround. What exactly, if you can tell me, what does that mean?
For one, I didn't have a case number.
Mm-hmm.
I did not have a case number, so that's why they said they couldn't pull anything up on the accident. And that's why I was asking, like, could someone pull the videotape? I literally was hit in front of 4th District front steps, and there were officers coming in and out past it. Nobody stopped. I had to call 911 just to get an officer to come outside.
Yeah, because this was right in front of, this would have been, 93rd and Kinsman is right in front of the 4th District. So I also want to delineate the difference between her experience with the police department in like 4th district
And
versus OPS.
So that's where I want to drill down on the experience with OPS when you tried to lodge the complaint with the Office of Professional Standards. What, as best you can remember, what's the time frame on that? And then if you were getting run around at that time, what was that?
I'm gonna say maybe 2023. Let me see. I'm gonna say about 20. I'm gonna say 24 or so because I kind of just gave up. I just gave up, basically.
Okay.
You know, there was nothing that could have been done, and I basically was just lost. I was just out. So I was just advised to file with you guys, and I just did it. So
Okay. So then whoever gave you that advice, that was clearly after
mhm.
the period that we could have. Okay. All right. Thank you. That's what I would do.
Okay, does anybody else have any questions, comments, concerns, statements? Okay, thank you again for coming. I really appreciate it. We really appreciate it. Yeah, we're gonna move toward our deliberations, so you can take a seat. Can you hit the button up there so it turns red? So you're not like getting like feedback. Thank you. Okay, so with that, would anyone like to make any motions on the case? Okay, I can make the motion. One sec. In case number 2025-0019 regarding Officer Daniel Sherlock, badge number 1569, for allegation A of lack of service, insufficient service. I move for a finding of sustained as the preponderance of the evidence, including written record as well as WCS footage shows and interviews, shows that the officer did not take the proper care to obtain information from all parties at the scene of the accident, nor did the officer properly assess the accident to determine fault before allowing one of the people involved in the accident to leave the scene. And so that was in violation of Manual Rules 4.03, 4.18, and GPO 8.01.02. I'll also note that the officer admitted that he should have taken greater care in this case to ensure that proper documentation was made and that proper care was done at the scene of this accident. So again, my motion is for a sustained finding.
Second.
Seconded by Member Parker III. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. I will note for the record that because we received this complaint outside of the 6-month window required by the CBA, that we will not be imposing, or that we are not able to impose any discipline on Officer Sherlock. And so no motion will be needed for a group level at this time. Okay. Is that good, Dahlia? Does that cover that?
Yeah.
Okay. So now, yeah, go ahead. No, go ahead.
To Ms. O'Neill, as you can see, we are constrained by some time constraints, but the board does find that the officer was at fault. It's as much as that can offer some comfort. That's what the board found. Okay.
It'll be in its record as a sustained finding. So, okay. All right, and so that was all we needed to cover on that case. Ms. O'Neill, you are free to go. That's all we have on your case. I mean, obviously, you're welcome to stay as well, but I wanted to let you know we're done with your case, so you didn't have to sit around and wait for us to do something else. But again, thank you for attending. I really appreciate it. Okay. Do we have anyone else here for any cases? Okay. Hearing none, then we will take it from the top.
Okay, the board, I'd like you to direct you back to appeals. You can find that on page 5. Be item number 1. OPS case number 2024-0202. Complainants are Tawny Smith and Nicole Smith, and Senior Investigator Bowker will do the presentation.
Okay, thanks, Mr. Boker, for that presentation. Does anybody have any questions for our investigator? Yeah, so this seemed pretty straightforward to me. I mean, the officers resigned. There's really nothing for us to do here. Thank you for the context of the timeline of when the officers resigned, because I did notice that one of the main complaints in the appeal was that we waited until the officers resigned and then we dismissed it, which is not the case. And I don't even want that to be something that people think is a practice that we do, where we're waiting around for officers to leave in lieu of us doing investigation, because that's not what we do. It also seems like this appeal is related to some sort of criminal case as it relates to the complainants, which really doesn't kind of go at all into a determination on whether or not a case is going to be heard or a case is not going to be heard. We're going to hear every case as long as it's in our jurisdiction, which this is not, because they're not officers anymore. Okay.
I have a question.
Yep.
So in this situation, we have a a resignation, we have a retiree. The case is clearly, there's not going to be any discipline, but is the case reviewed by OPS at all? And I think we've asked this question prior. An officer could hypothetically resign knowing that there's a case out there that doesn't look good for him. That this is all hypothetical, of course. Resign, the case gets dropped, and then they could go apply somewhere else and have nothing on their record. There's nothing that reflects in the record whether this complaint was legitimate, was sustained, was dismissed because of the facts of the case didn't support it, so it was unfounded, or the officer was exonerated. Do we do that type of review? And I thought that we had had discussions once upon a time regarding that, to at least put in the officer's file what became of that. In the event they came back and said, yeah, I resigned a couple of years ago, but I want to be an officer again.
Oh, the one officer retired.
Right, okay. They can unretire though. Could they not? Okay.
If, position on that. He's not.
No, I understand that specific case. I recall it. It was, they pulled a guy out of a bar, not unlike what the complaint here was maybe. So in this case though, because we know that that officer is unemployable back again because of a felony, the officer that retired hypothetically could say, I've reconsidered my retirement. I want to come back to work. And the only thing that's going to be in the file is this complaint. And there's not going to be anything that sustained or exonerated that officer from this case, correct? They would just look at it and say, well, there was this, but no decision was ever made. That officer would be eligible for consideration of rehire because there's nothing that's been decided on this case. And my concern is maybe not specifically in this one, and who are the participants, and what's the likelihood of an officer retiring and coming back to work? I think it's probably remote. We know the other officer won't be reapplying. If he does, it's going to get turned down immediately anyhow. But sans that, let's say it was two other officers or another officer that left the department to go work for the suburbs. And we have the case and we say, nothing we could do about it, it's administratively dismissed. We don't rule on that case. That officer, not of retirement age, decides, I don't want to work in the suburbs anymore, I want to come back to Cleveland. We wouldn't have a record of, did the board rule on the facts of that case? Is that correct? Or because of this specific case, there was no reason to proceed, in your opinion?
Well, there will not be a record of on this case, but it also would not be an exonerated file. So you would have an outstanding complaint that was never resolved. That's just regarding this case. That's not to say they don't have other cases with OPS doing the findings. But you're correct, there isn't a change rules to exonerate. It's a complaint was filed, because he left the department.
I guess I just want to express I have a concern regarding that. In our prior case, it's administratively dismissed because of the timeline. we still make a ruling on it and nothing happens discipline wise. And in this case, my concern is kind of what I expressed. Could somebody come back to work? And I would say that it would be unfair if somebody were to come back to work and say, I want to apply, and they said, well, you have a complaint out there. Well, nobody ever investigated the complaint. Nobody ever ruled on the complaint. A complaint was made to the review board and it was just dismissed. So it'd be unfair to say to that officer, so we got to take that into consideration if we're going to bring you back or not, because it's in limbo. And I doubt that at that point they say, well, bring it back to the board to adjudicate whether there's discipline or not. So my opinion is we should be ruling on these administratively dismissed cases on the merits of the complaint. And let it fall where it may in terms of that. Just like any other case, maybe the facts are clear that the complaint should be sustained. Maybe there's insufficient evidence that, we have the 5 categories we can rule. But I think we ought to kind of close it and have that in the file. That's one man's opinion, I guess.
And so let me really quick echo the comments, because I had this concern many times that when we do this, that something goes in that file. I've always been concerned, to my colleague's point, always been concerned about a proverbial loophole. And I think this presents the same thing. We should go forth. Whether we have jurisdiction to administer discipline, I think is something completely different. But I would not want somebody to use this loophole, not have us render an opinion, nothing in the file, and then for some reason, of all the examples that you just named, the person could come back and reapply, and then there's nothing to tell that hiring person that there was an issue. I think these cases should go forward. Whether we can discipline or not, this should be put in a permanent jacket. So if they were to reapply by some stretch of the imagination, it would be there so somebody could review it.
Gentlemen, if I could.
You can.
I agree with you. With my experience in law enforcement, the best practice is to carry these investigations all the way through their conclusion, to have a ruling had, and it will really be in their file, regardless of the fact that they have separated either through resignation, retirement, whatever. That's the best practice. And actually, I'm being relatively new. I'm looking through OPS manual and identifying things that I believe we can improve upon, and this is actually one of them. I'm going to be making a number of recommendations for the modification of the manual with the rationale why in the relative near future. But this would be one of the instances that I would agree with you and have already identified that that's not a very good practice for the reasons you have stated.
So I want to commend you for that, and really expect to see this full throated, because I think in the past we've been just constrained to, well, it looks like that this meets a standard that we won't be able to administer discipline, or they left, so let's not do anything. I think we've been constrained to that for far too long, and I want to see this loophole filled.
Okay, does anyone else have any questions, comments, concerns, statements? I don't know that there's anything that we need to do on that point right now. We are absolutely looking forward to any changes or suggested edits that you have for our manuals. I know in order to change the manual, that's a process for OPS or for CPRB. So, that's a road that has to be traveled. But that doesn't mean that we don't take those steps to start traveling that road. So we'll be looking forward to that, and including, just keep in mind these discussions that we're having when you're looking at the OPS manual, that it seems like the board certainly has an appetite for us changing the way that we are currently approaching some of these officers who retire or resign, pending investigation. Okay, as it relates to this particular case, I don't know if anybody wants to make any motions. I don't know that we. Um, I mean, I know for the other appeal, I made the motion that we uphold the dismissal. I'm kind of inclined to do that again for this particular case. But if board members have other thoughts where they want us to open this and adjudicate it, or we'd have to investigate it first. Then I will entertain that motion as well.
Chair, and I know this is gonna get sticky. Is there any way, and well, we don't necessarily know how this is going to turn out if it was to be investigated. Let's not take that leap. But keeping in mind that the administrator has indicated that he's identified an issue with the way that these go, is there any way we can table this, or should we even table it, or just go with what we have, go with what our purview is right now at this moment in time?
My thought would be not to table it because it's going to take a while for us to change the manual if that's what we'd be tabling it for. And I wouldn't want to table it for us to revisit this in 6 months, 8 months, or however long that could potentially take. I mean, looking at this case practically, we know Detective Kopchak's not coming back and is basically unemployable by any other law enforcement agency. The other detective that's listed was hired in 2023, which doesn't mean that they're absolutely not coming back, but I think it'd be surprising if they did at this point. So I think from a practical standpoint, I don't know that we need to open up and and do a full investigation on this case. But those are my thoughts. I don't know if any board members have any other thoughts or feel strongly about wanting to open up and investigate this.
Chair, just from my understanding, is this policy or practice that we dismiss those types of cases?
Currently, it's policy that we dismiss the cases under our OPS manual, but there's nothing that requires that under 115. We kind of made that assertion that if we can't impose the discipline, then I think for efficiency's purpose was the original kind of thought process behind it. We're not going to go through with the investigation because the officers are no longer here. We can't really do anything. But what we've identified, and Dave and Billy have talked about it as well, that does still have some potential ramifications down the line if the person, tries to double back or go to another department or something like that. So, but currently, to answer your question, it is policy that we don't investigate these cases.
I could say it also impacts our ability to accurately evaluate data, because if we're not going to be investigating this case through to its final disposition, we don't know what cases are being sustained, what trends may be actually out there that we're going to be missing, because this isn't a rare occurrence necessarily that we have these cases that are dismissed. And it can really skew our perception of what's really going on.
I would say too, there are live examples of officers that should have not been hired for reasons. And this, you would want that person who does hiring to have this information available, this protection of the public, where this person has exhibited that they should not have the honor of being called a Cleveland police officer. These kind of things should be in that jacket, for sure.
I'd add just one more thing, that I think there's an important part of our role is when a citizen makes a complaint, no matter what their position is, where they're at, or what's going on, their complaint has a right to be investigated. And I certainly understand the rationale here of, not looking at it based on the facts of what were going on with officers, but there's still a citizen out there that would say, I had a complaint, and just because these guys aren't there anymore, they're not even giving me the satisfaction of going through it. So publicly, someone can say this officer, this complaint is valid or not. So I think that's another thing that we have as a responsibility. regardless of the discipline and what goes on with the officer in the future, we have a responsibility to the public and the citizens when they make a complaint.
Okay, does anyone else have any other thoughts, questions, comments, concerns?
I would just make an observation.
Sure.
When an officer leaves the department, he's under no obligation to talk to us. So we'll never get their version of what happened. Their statement, either pro or con. So, yeah, we could continue to do the investigation, but it's not gonna be the investigation of, in the scope that you're accustomed to. You won't have the officer statement. And additionally, when you have a case this old, the evidence for this is, I think the incident occurred 2011. Finding the records, if the WCS is still around, it brings a whole host of issues. Currently, we have no provision in the manual that says, well, we're not going to do anything if it's 5 years old. We have to investigate everything. This would just add another case where we're having to investigate the best of our ability, knowing that, certain pieces of evidence, such as the officer statements, are not going to be part of that file.
And I would submit that that's understandable. I follow the process that was taken here. There's still a citizen that made a complaint, and an answer back of, this happened 15 years ago. We don't have all the evidence we need. We can't make the officers talk. We're gonna rule insufficient evidence on it if need be. At least that gives the citizen, this is how your complaint was adjudicated by the review board.
Yep. Member Willis, did you have something?
I echo the sentiment of our colleagues. I think that whether the officer leaves or not, if we do choose to investigate the case just to serve the citizen that made the complaint that deserves it to be investigated, we should make a protocol to at least give the officer the opportunity to comment. And it's up to that officer if they would like to comment or not. But we'll have it on record that we gave them the opportunity and they chose to decline if they choose to do so.
Yep. No, I agree. I mean, all we can do is investigate it to the best of our ability whenever, the investigation is ultimately in front of us. Okay. All right. With that, I'm going to move that we uphold OPS's administrative dismissal of case number 2024-0202.
Second.
Seconded by Member Sharp. Those in favor say aye. Aye. Any opposed? Any abstentions?
And I will not have a full conversation.
All right, one abstention from Member Parker. And that motion carries. Okay.
I'd like
Move
to
on to the
direct
next one.
you to case updates. You can find that on page 6. It's OPS number 2023-0140. It was last heard on August 13th of 2024. And Senior Investigator Booker will be presenting.
This case was presented to the chief by imposed discipline because of the contractual procedural timeliness contained in the imposition of discipline. The hearing officer recommended the case.
So what exactly was untimely? Like which part of this procedure was untimely? From us?
And then, I think that was the fact that, the time frame, it was just, once the clock starts, once they get it,
Okay, so this case was heard in August of 2024. I'm assuming that that is when we made this sustained finding in August of 24. And when did we provide notification of that sustained finding to the chief's office?
when the finding started.
Well, looking for that. My understanding is that as far as timelines go, and I think it's probably a good time to bring this up, we have a couple kind of parameters that we always need to be aware of as far as timeliness. One is that the complaint needs to be, the officer needs to be notified that there is a complaint against them within 6 months of the incident occurring. I think we all kind of know that when we run up against that a lot. But there's no timeline for which we are required to investigate complaints. From my understanding, there's no timeline on which we have to complete an investigation by. However, once the investigation is complete and we render a decision, and then the chief conducts a hearing, the hearing then triggers another timeline in which we have to impose, or the chief has to impose the discipline within 60 days of the hearing. Is that right? Based on your understanding or anybody's? Okay. So, and then currently the timeline is that there's one more, when we make a decision, and let's say we make a sustained finding, the chief has 10 days to make a determination about our finding. 10 days after the chief receives our finding, they have 10 days to figure out whether or not they depart from our finding. They have 10 days to do that. And then, like I said, once they do the hearing, then there's 60 days from there. What I'm trying to figure out is where in this process did this happen that allowed the chief to then make the decision that our sustained finding would not be upheld. At least no discipline would be rendered.
Just did we have the finding letter?
The findings letter was sent August 15th, 2024.
The findings letter was sent August 15th, 2024.
So 2 days later.
That's 2 days later.
So how do we get?
So,
Sorry.
Well, when was the decision made by the chief? When did the decision, chief made this beyond?
The date on the agenda is when the departure was heard, not when it was first heard.
Oh, this is the last one.
Yes.
So what is the actual date when we last heard the case? So when you say the finding letter, that is a result of what we heard on the 13th, the one that was sent on the 15th, right?
Camille, was for the interest, in the interest of time, because this is not really time sensitive anymore because the chief has already made this declaration. I just want to be clear about whether or not this was untimely because we got them something late, or whether it's untimely because they conducted a hearing late and didn't notify us in time. I will also note that this all happened in 2024, which I believe is before our manuals went into effect, updated manuals went into effect. And so therefore, at the time, the chief was the final arbiter of discipline. So it wouldn't be that the chief didn't impose discipline that was required by us, because at the time the chief was the final arbiter. So it's not necessarily that, but I do want to know what the timeline is before we can even really seriously be able to understand what happened here. Does that make sense?
Yeah, because I would say, Chair, we want to know that, because if we have a gap in our operation,
Right.
we want to know that.
So yeah, so we'll table this for well, I'll make the motion. I move that we table OPS. Yeah, this isn't even open. Just an update. But I move that we table discussion on OPS case number 2023-0140 until our September meeting, so that we can obtain a clear timeline on when the case was heard, when the police review board made their sustained finding and group level recommendation, when notification of that finding was sent to the chief's office, and a timeline of what the chief did with that finding and when, and ultimately so that we can discuss how this case ended up outside of the timeline required by the CBA.
I second that motion.
All right.
Just brought this up. Do you want to read it?
Yeah. Okay, so the case was presented to the board August 13th, 2024.
Okay, wait, sorry. Hold on. I'm going to interrupt you really quick just to say the motion has been seconded and we will open for discussion before we make a vote. Sorry, just a Robert's Rules thing.
The board sent the findings letter August 15th, 2 days later, 2024, recommended unprofessional conduct allegations be sustained. The pre-disciplinary hearing went before the chief on July 28th, 2025. The board reviewed the chief's departure on November 11th, 2025, and reaffirmed the sustained finding. The board issued an amended findings letter on May 20th, 2026, reiterating the recommendation for corrective action.
Okay.
So,
1 second. Hold on.
So between the findings letter and the chief's hearing, it was about 11 months.
Okay. So, but again, and I want to be clear about this, just for our sake, so we know, there is no timeline restraints that trigger for the distance between the time when we make a decision and when the chief has their hearing. From what I understand, the timeline triggers once the chief has the hearing to when the discipline has to be imposed. So technically, the chief can take a year to do the hearing, but once the hearing happens, the discipline has to be imposed within 60 days. Is that OPS's understanding? And I see my lawyer is shaking her head. I mean, nodding her head.
That is my understanding.
Okay. So so it took the chief about a year to have the chief's hearing after our sustained finding. Especially efficient, technically that did not make it so that discipline cannot be imposed. But after the chief's hearing on July 28th of 2025, we did not hear the case again until November of 2025, which would have been already outside of that 60-day window in which we're required to levy discipline.
so then my question would be, why is that? Because then that's an internal issue that we have.
Right. So, well, do we know when the chief told us that the hearing happened? Because we wouldn't be able to, it wouldn't be in front of us to review the chief's decision
Until we were
of
aware.
departure until we were aware of it.
Mhm.
That was the same issue that we had, like 2 months ago?
I think we had a similar case a few months ago where the chief gave us their departure letter within days of that 60-day requirement, and we had to have
An emergency.
an emergency meeting in order to meet the 60-day window.
Yeah.
We got the departure letter August 1st, 2025.
Okay. Okay. So the chief gave us their departure letter August 1st, 2025, which was like 3 or 4 days after the hearing. And then between August 1st, so August 1st, we got the letter. We did not even contemplate the departure until November 11th of 2025, which would have again put us outside of that 60-day window.
This is,
And it
it
was
was on our agenda. I'm not sure if it was heard for August 27th, 2025.
okay.
Weeks after. Now, I don't know if we didn't get to it. I don't know what happened, but it was on our agenda to
In August.
review, and we typically are, historically, we've been pretty good at addressing departures, not saying let's push it out because
Right.
we're aware of the timeline. So
Anybody have any recollection what could have happened around that time that we didn't get to it if it was on the agenda?
I mean, we'd theoretically be able to pull the minutes and see.
A bit of a change in staff, August, September.
I was gonna say August, September was around the time. That was, yeah, we did have some changes around that time. And I think Jalecia started, when did you start? So this was I think one of the last meetings before Jalecia started. So something happened there that somehow caused us to not review it until November 11th, which again put us outside of the timeline. Now, there's another issue, which is that even after we made that departure, the letter notifying the chief of this departure did not go out until May 26th of this year, or May 20th of this year. Either way, one of those days, May of this year. I'm assuming that was due to the backlog of findings letters that we had and the time it took to clear that.
I have a note that says the departure was supposed to be presented September 9th, 2025. It was tabled to the October meeting because the written rationale was insufficient and they wanted clarification. Well, y'all wanted clarification on your ability to clarify what you meant. This is sounding familiar now. Yeah.
What the chief meant?
What I think y'all wanted to know if y'all could clarify what you meant to sustain.
Okay, in our original sustained finding.
Yeah, she explained something different and you're like, that's not what we meant. So it was tabled.
Okay.
Well, then we didn't have the time to do that. Actually.
Okay. All right, we're getting to it. It's taking a while, but we're getting there.
We might have to eat this.
Okay, so it sounds like this was originally put on our agenda in August. We're not sure why, but it got pushed to September, and then we tabled it in September because we wanted to try to make it more clear what we originally said. So then it would have got put on our October agenda. Somehow it got pushed again to November. But I think it's very clear that it was in front of us for a significant amount of time. So as the board, we need to be aware of this 60-day window. And I think that at this time, we're not really aware or appreciated the 60-day window of time that we had from the end of the chief's hearing to when we have to, or from when the chief then has to impose a discipline. It was something that was kind of made clear to me this spring when we had to have that emergency meeting that, hey, you only have 60 days. So long story short, long story long, because this has definitely been a long story long. It seems like this is on the board in part. I do want to make sure that we are all on the same page about the fact that when we get these departures, we have to make our decisions quickly. To whether that means that we're sustaining what we originally did or we're changing it, whatever discipline is going to be imposed, it has to be imposed within 60 days of that chief's hearing. Now, what is also on my radar is that if the chief takes a long time to get us their decision, then that gives us a shorter window to be able to make that decision. So what I'm hoping is that the chief gets it to us with kind of 30 days notice. So that way, at some point in that 30 days, we're going to be meeting, right? As opposed to us having to schedule emergency meetings in order to meet these deadlines.
I would,
Do we have any other questions about this?
just the last thing.
There's also a motion still on the floor. I haven't forgotten about that. We're just still in discussion.
To the administrator, could you help us out in keeping timekeeping on these things? Because there's two things I don't want. I don't want the chief to have the ability to put us in a situation where there's days left to render a decision because of time constraint and it's done on purpose. Don't want that to happen. So we need a time clock on that. And then a time clock to say when these come before us and the board likes to deliberate and likes to get stuff clear, that's great. But we need to know at that point, hey guys, you don't have that much time. So the request that you're making, which is to go back and find out what you actually said and get it right, you don't have that time. And kind of press us into making a decision so we don't have this situation happen again.
Yeah, absolutely. I'm actually currently working with Elizabeth. She's our data analyst. And part of what she's doing is putting together audits and things to track our compliance of our policy and our timelines within the office. So we will ensure that we have something that will put up a red flag. So we're sure that this doesn't happen in the future.
Because that's even sending a note to the chief saying, hey, we're close on this time frame. What are you doing so we can get this done in the right amount of time?
Right.
All
No,
right,
I appreciate that. Mhm.
No, it's okay. Okay, so we have we currently still have a motion on the floor, and it's already been seconded, so I don't really want to withdraw it. We could also just not vote for the motion because the motion is to table it, and I don't think we need to table it anymore.
I agree.
But it's already been seconded, so we need to proceed with the vote. Okay, so the motion on the floor is to table this case. So all in favor of tabling, say aye. Any opposed? Nay.
Opposed.
That's close. I think I got it. Who else said nay?
Nay?
Nay. 1, 2, 3. Uh-oh. Any abstentions?
Think it's the time?
No, I don't think who else said aye?
The table.
2, 3, 4.
Oh, no, it's 4.
Yep. Okay, the motion carries. So
Table it. No, okay. What are we tabling it for though?
we have slayed much bigger beasts, guys. What are we doing?
Can we make a motion to rescind that? To get it right? I mean, there's no reason to table it. We'll put somebody through some extra work for nothing.
Somebody else can make a motion. How about that?
Okay,
You guys, what you want to
I'm
do?
gonna make a motion. I'm making a motion that we rescind the previous vote in its entirety. And to further make a motion that that we stick with the chief's findings.
I second that motion.
I'd like to have a discussion on this. The dates here are just not lining up with when we heard the cases. When they were on our agenda, I'm not finding minutes for September of 2025 that would reflect that we rule on it on the 27th. We now have what is a second, I guess, departure letter of the 4th. We're on the 11th. I don't know what our deadline is to respond to that one. So I'm not comfortable with the various dates that have been kind of thrown around, that the chief is correct, that the timeline is missed. But we may miss the timeline if she sent a departure letter on the 4th and we don't make a ruling on it. So that's the reason why I think we need to table and find out what are these exact dates, because we've had different dates already mentioned. I don't know that the chief is correct. Chief might be correct. But I don't think I don't feel comfortable we've been presented with information that tells us that the timeline's been missed. Again, I don't know what happened on that August 27, 25 meeting that was clearly on the agenda as a chief's departure. Did we just miss it? Did we ask for something else? Because we usually can't do that because we know we'll miss a timeline. So somewhere there's got to be, I would hope there are minutes for that August 27 meeting. I'd like to see what was reflected there. And if we missed it, we missed it. If we didn't miss it, I don't want to move forward and just say, well, we missed it when in fact we didn't. So I would stand by the tabling it on that basis. There's another motion.
That's it.
Is there any further discussion? Okay, can you restate what your motion was? Because it was already seconded, so we need to vote on it.
Okay, so my motion was to rescind the last vote in its entirety and move forward with the chief's recommendation on this case.
Okay, so we have a motion on the floor to rescind the last vote, which was to table the case and just move forward with the chief's departure. And Member Gatton has noted that he would like to see us get more information before we decide to go forward with the chief's departure. But again, the motion is to rescind the last vote, just to table the case. So, does anybody have any questions about that?
I can't make an amendment to that, can I? Since it was second.
I think yes, you can. You can amend the motion.
Well, the only
You can make a motion to. You
thing
have to move to amend the motion.
What?
You have to move to amend the motion.
So I'm saying I move to amend the motion?
Yep.
So I'm moving to amend the motion to just simply include for edification's sake, what Member Gatton spoke to is that we still get the correct timeline. Meaning that we still get the report on what the actual timeline really was.
Okay. We have a motion on the floor to amend the motion. So this motion is to amend the other motion that was on the floor.
Just right to get to right.
Can I get a second on amending the motion? Seconded by Member Miller. All those in favor say aye. Aye. Any opposed? One opposed? You can make a statement if you want to, but you don't have to.
I just think there's a possibility we still may be missing a window. We could make a ruling chief's dismissal.
Mhm.
That what hearing of the motion may make that happen. That's my objection.
Any abstentions? That motion carries. All right, so now Billy's motion has been amended to include the caveat that we would like to obtain the information from OPS about the exact timeline and to confirm whether or not the chief's departure rationale is accurate. So now that is part of the motion.
Mm-hmm.
All those in favor, say aye.
Aye.
Any opposed? Any abstentions? One abstention.
He's on his way out.
One abstention?
Yeah.
Okay. One opposed? Okay. Okay, for same rationale. Okay, that motion carries. Okay, so as it stands, we are not tabling the case.
Right.
However, we are asking for OPS to we are asking for OPS to come back to us and let us know whether or not the chief's rationale is accurate. Does that make sense, guys? I know this has been like super confusing, but basically at this point, we just want you guys to come back and let us know, hey, are we actually outside of the timeliness procedures that are required? Does that make sense?
To give the board some comfort, I will meet with her personally.
Okay.
To speak specifically about this case and report to you at the next meeting.
Yeah.
And if I have information prior to that, I will tell you, the chair, prior to, so you have the knowledge as soon as I have it.
Okay, that works. I mean, I'm pretty sure that the chief's rationale is correct, but based on motions, if you guys can go back and just double check and make sure.
And we want to know if we fumbled the football too, as
We
well.
definitely fumbled the football.
Because if we fumbled the football, then we need to get ourselves in order.
Yeah, we definitely fumbled the football. But I also think we fumbled it because we didn't really appreciate that 60-day timeline from the end of the Chiefs hearing to when discipline has to be imposed. So now that we know that, we can move forward. We are moving at a blazing pace today. Just so you guys know, we are absolutely gonna have to stop at 12 in order to get through executive session and the other things that are on the agenda. So there's a chance that we have a good amount of cases pushed to next meeting. Or that we'll have to have an extra meeting. Welcome to my reign of terror. This is like this is second term reign of terror, like when I don't have to worry about getting reelected.
Nominated.
I don't know, but you guys got this. Okay, we can move on to the next case.
Okay, I'd like to direct you to the bottom of page 6. It's the internal affairs involved cases. It's going to be item number 1, OPS case 2025-0086, Part B. The complainant's Michelle Knopp, and the investigator presenting will be Senior Investigator Oker.
This particular complaint was filed on April 18th, 2025 by the complainant Michelle Knopp against Officer Brandon Jones Park, badge number 1598, and Sergeant Albert Oliver, badge 9220. Before I go on, she actually filed 2 complaints. The first one had to do with a totally different incident, totally different officers unrelated to this. So we decided to make this, bifurcate this into a sub B. You will hear A later on, but this particular case takes some precedent, and we wanted to get it presented. Her allegation against these 2 officers, particularly Officer Jones Park, is he engaged in unprofessional behavior or conduct after he responded to her home for a separate service call. She alleged that he had contacted her via cell phone call and telephone messages, using his personal cell phone to make comments about her appearance, questions related to her pregnancy, other inappropriate discussions. She further alleged that he had told her he would come to her home at the end of his work shift and requested that she leave the back door unlocked. The complainant alleged that she told Sergeant Albert Oliver on April 19th about Officer Jones Park's conduct, and that he failed to provide her with any follow-up information. OPS is recommending a sustained finding for the unprofessional conduct, as well as some other allegations that will go into, and it exonerated for the lack of service allegation against Sergeant Oliver, because he actually referred her concerns to Internal Affairs out of concern that there was a possible criminal violation, specifically telecommunications harassment. So OPS gets the complaint at the same time Internal Affairs gets the complaint. Internal Affairs completed an investigation involving Officer Jones Parks, which resulted in no papers being issued on the telecommunications harassment charge due to insufficient evidence. However, they uncovered additional allegations of improper procedure, failure to activate WCS when Officer Parks Jones contacted the complainant. He initially had started the conversation out to gather information for the report, and then it gradually transformed into something more personal. Well, he didn't activate his WCS for that call. They also found that he had contacted her using his personal cell phone, and he was actually issued a city cell phone, and he was required under the GPO to use a city cell phone. They also found they had actually asked to see his cell phone and found that he had engaged in similar conduct with another female that he had come in contact with. He had met her on a service call and contacted her, texted her, non-business, essentially starting off with to get more information for report. He didn't activate his WCS. Again, he used his personal cell phone. They also found that from looking at his cell phone, that while he was working, he had viewed pornography when he was on job site. It was actually showed up on his cell phone when they examined the cell phone. Now, Internal Affairs, when they conducted the, besides looking at the cell phone, they actually did a Miranda warning because of the criminal charges. And they actually asked him, besides our complainant, did you do this? Did you engage in this any conduct with anyone else? And he said no. Well, after they saw the cell phone records, they realized he had, in fact, contacted a second female. So they had charged him with lying. OPS also interviewed Officer Jones regarding all the allegations that were uncovered and got admissions from him, statements that he realized he was wrong and shouldn't have engaged in that such conduct. So again, OPS is recommending a sustained finding for unprofessional conduct, which is violation of Manual Rule 5.01, and that pertains to his communication with her on a personal nature on the cell phone and the texting. On allegation B, harassment off-duty conduct, OPS recommends a finding of unfounded, and the rationale being that he did drive by her house, but he never had contact with her. He never went to her house. He just drove to the house. So OPS recommends on the harassment allegation to be unfounded. OPS recommends improper procedure, failure to activate WCS 4.06.04 be sustained. And the improper procedure, personal cell phone use, OPS recommends a sustained finding on 4.6.12 that be sustained. And OPS concurs and recommends sustained findings on IA specifications, which is which one am I at? Number G. Yes, number 7. The improper cell phone again, where he contacted a female that he wasn't supposed to on his personal cell phone, and he also did not activate his WCS during that conduct, and also engaged in unprofessional conduct by communicating with her on a non-business related purpose. And finally, OPS concurs with an unprofessional conduct false statement specification that IA had where he'd made the false statement, a violation of manual rule 3.12, which has to do with the making a denial that he didn't do this, engaged in this conduct before, when in fact he had. He had made a false statement to internal affairs during the Miranda warning that he received. And if I hadn't noted it before, the lack of service allegation against Sergeant Albert Oliver, badge number 9220, OPS is recommending exonerated because Sergeant Oliver did immediately refer the matter to internal affairs, and he was not under obligation to specifically say that he had follow her up with a call to say, I referred it to IA. So OPS recommends he be exonerated. Oh, and I have a note here that he got promoted to a lieutenant. So that's difference.
Wait, say it again?
Oliver got promoted to a lieutenant. So he's no longer Sergeant Oliver.
Is that his correct badge number, 9220?
No, it would not be. The new badge number is,
New badge number is 8586.
8586.
86.
no, what, he just got promoted on that.
Okay. Thank you for that presentation. I do have a couple questions so I can make sure I have all this in order because we have a lot of allegations. I'll start at the end with Sergeant Oliver. So is that what we have listed? If you look on the bottom of page 8 for us, this is allegation J that has a lack of service exoneration, but it has Officer Parks listed. Should that actually be Lieutenant Oliver?
Yes.
Okay.
It should.
Okay.
Say that one more time.
So under allegation J at the bottom of page 8, it's a lack of service allegation with an exoneration recommendation. That should be for Lieutenant Oliver, badge number 8586, instead of Jones Parks. I got some other questions about the other allegations. I just want to make sure I'm in order about which allegation is for which conduct. So when we're making the motions, it's clear. Okay, allegation A is for the communication on a personal cell phone for his communications with the complainant on his personal cell phone.
Voice and text.
Voice and text. Okay.
And he sent her a series of text messages.
Okay. And those were non-business related, right?
That's correct.
Okay.
He did that on his personal cell phone and the work cell phone.
Personal cell.
Personal cell phone.
Yeah, he reached out to her extensively to get more information.
Right.
And then the conversation flowed.
He steered it somewhere else. So he kind of act like he was trying to get some more information, but really he was, yeah. Okay, allegation B is the harassment. So this was related to him driving past her home. Did she know that he drove by?
No. That was found out by IA.
Okay.
That he'd actually driven by him. But he had no contact with her. So.
Is that the benchmark for harassment? Having contact with the individual?
I'm sorry.
Is that the benchmark for harassment, even though driving past her house was
I would say it's unprofessional conduct, but.
Yeah, I think that may be under allegation A. I don't know that it's harassment if she didn't even know he was driving past.
She didn't know about it. She didn't know about it.
So that's why you're saying
It's-
unfounded.
Yeah.
Well, I don't
He
know.
had
This,
not that, he had no contact with her at all. So he just drove in the neighborhood, which is otherwise okay, except for his state of mind, but it's not harassment. Harassment requires more of a interaction. Yeah. It's creepy, But it's.
But that's what I'm saying. I don't know if it's unfounded though. I don't know if it's unfounded. I think it might
I
not.
think it might be an exoneration.
Right, it might be exonerated, but not unfounded because he did actually do it. It just doesn't rise
To the
to,
level.
because unfounded to me is like there's nothing here. There's
Yeah,
something here.
But he didn't harass her because he didn't have contact with her.
Yeah,
I get
you have to fill, in order to have exonerated, you'd have to say that he actually completed the conduct that could constitute harassment. However, it doesn't rise to that level. To have harassment, she would have had to have some knowledge that he actually did drive by. In her statement, she turned off all the lights, pulled the blinds, went to bed. She had no clue. So there is no way that harassment possibly could have occurred. So had the harassment occurred and we evaluated it and said it doesn't rise to the level of harassment, then that would be the exonerated. But the unfounded is it didn't happen. We're saying it didn't happen as the elements of harassment. If you want to include it under unprofessional conduct, absolutely.
Okay. Okay.
Yeah, I think this one is close. I mean, this one is close because I do agree with you, Billy, that the alleged conduct did occur, but it does not meet the criteria for harassment, which to me would be exonerated.
Right.
Because we're saying the focus is on the conduct. Did the alleged conduct occur? The alleged conduct did occur. The alleged conduct being him driving past.
Right.
Unless the alleged conduct was that she saw him drive past. Now, if that's the alleged conduct, then it's unfounded.
Right.
I don't want to, we've.
Yeah, the alleged conduct here is a result of the investigation conducted by IA. The complainant did not make this particular allegation because she had no knowledge that he did so.
I mean, I don't have a problem with unfounded. I think the record will be clear.
The complainant didn't make the allegation about him driving by.
Yeah, she had no knowledge.
So then we later found out through investigation that he did drive by.
IA did through.
So then how could it be unfounded? It's because we found it and he actually did drive by.
Because to complete the elements of harassment, he would have had to have made contact and harassed her in some way. His behavior was unprofessional, and it would have become harassment.
Why didn't we say unprofessional?
That's why we're not sustaining it, because it doesn't meet the level. But the question is whether or not we say it's exonerated versus unfounded. Unfounded makes it sound like the alleged conduct didn't occur, but the alleged conduct did occur.
I get what you're saying. But let me take this slower. If the complainant said harassment, yes or no?
No.
That's something that we found. So I'm saying, why did we say harassment if harassment didn't exist?
Well, it's an allegation.
Why did we make the allegation?
Because I don't know, to evaluate whether it's done to evaluate whether or not it meets the criteria.
The telephone harassment.
Yeah.
And that's how it got into the.
Now, if you want to encompass the telephone communication as harassment, I would sustain that. But if you're looking in isolation, him driving by, it doesn't meet the elements.
But I'm saying, if we're making the allegation, why would we make an allegation of something that we know doesn't meet the standard? Then why didn't we say that use the telephone as the example for harassment? If the complainant's not saying harassment, we are, because that's what our investigation found. Why wouldn't we use the telephone instead of the driving by? Because the driving by, there was no contact. I'm saying, why didn't we get it right?
I think you could add the allegation.
You could put, to make things simpler, I would put the allegation on professional conduct, all the things, calling her, texting her, the driving by her house, just that all into unprofessional. And I would say, the telephone harassment / harassment, unfounded, because it was no papered. And for the same reason, he had no contact with her. That's how I would resolve that.
And Mr. Boker, I agree with you. I'm just asking, why didn't we do that?
Yeah, so I get what you're saying.
It's in part because this was handled initially by IA, and that was one of their specifications that came to us.
Did they sustain that specification? Did they sustain it?
Because maybe IA sustained it, but we're saying under our review, we're not gonna sustain it.
Now,
right?
now it makes more sense.
But
Now,
but the other thing is, you can also, I can also see a world where you put the allegation down for the sake of evaluating the allegation, even if ultimately your evaluation is going to lead to you saying that it doesn't rise to this level, but you still want to contemplate it.
So now the problem is my interpretation, because I was under the assumption that we found this allegation, not that IA found it, and we're disagreeing with IA's finding, and that makes sense.
Specification 1 of IA's investigation mirrors our allegation A. Specification 2 of IA's investigation, which is the harassment charge that we have, they sustained, saying he completed his tour of duty, drove to the female's residence that he had contact with the intent to visit her. They said, even though he didn't have contact with her, that's a problem.
That's not harassment. Okay.
It's just not harassment.
But it's not.
It's not harassment. Okay, now I got it. I'm sorry. I just had to I got it.
Sorry. Okay. It's on brand for today. We're all good.
Actually look at what they do
Got you.
and make our own independent interpretation of what we believe in that.
Now I'll say, if somebody would have raised their hand and said this was an IA allegation, then I would have not had to go through all of that.
It does say IAU specification number 2. I just
pointing things out that I missed.
Okay, move on to allocation C. So the failure to activate the WCS, that would have been during one of these phone calls to the complainant. Okay. Specification 4, improper use for improper procedure, for personal cell phone use. Is that for like the pornography?
No, he was
Was that
required to use his official, he was issued a cell phone. For official purposes, when you're doing an official investigation, you're supposed to use the city's cell phone.
okay? And that's separate from saying that in allegation A, he used his personal cell phone for.
Well, we're just identifying what device he used. It's the communication that's improper.
Okay. I just want to make sure we're not being duplicative here.
One is the content
Right.
messages. The other is you weren't supposed to use that device to make the telephone call ostensibly for.
Right, for business. Yep. That makes sense. Okay. Allegation E is also listed as professional behavior. This is for. No.
Oh, E is actually the lack of service allegation.
E is a lack of service allegation?
That's against the sergeant or lieutenant. The report's not a little different than how it's lined up.
So this says IAU specification 5. So what's IAU specification 5?
That is on or about April 12th, he contacted another female.
This is the second person you
That's
contacted.
the second person you contacted.
Okay. And that's unprofessional behavior.
Yeah, he basically did the same thing, called her up.
Yeah. So this allegation is similar to allegation A, but for a different person.
Different person, different date.
Yeah. Okay.
And should that have been stated? I was gonna say.
We'll state it during the motion. That's why I'm going through this, so we'll make sure it's stated during the motion. Okay, allegation F is WCS for those phone calls to this second person.
Yep. And then the next allegation is using his personal cell phone to contact the second female.
Yep, for second person. So, right. Yep. Okay. So what is now allegation H? Is it third person?
No, this is the looking at pornography on April 19th.
Okay, so this is pornography. Okay.
Now he is looking at pornography on his work phone.
No, he's looking at.
This is personal phone.
Personal cell phone.
But he's doing that on the clock.
Okay, gotcha.
And he he made statements like, "Oh, I thought it was just open and I wasn't looking at it more than 5 minutes." But still-
Right.
Oh, we'll get to that. We'll get to that. First we gotta sustain, and then we will figure out what I is talking about for discipline. Okay, false statement is him saying that he only contacted the complainant and not the second person.
Right.
And then allegation, and then this last one is the one for Lieutenant Oliver.
Yeah.
Right. Okay, I think I got it now. All right. If you guys don't mind, I'll make a motion.
It's rather simple. He did the exact same thing to 2 different
Right.
facts with a little other stuff added in there.
Okay. Moving at a breakneck pace today, guys.
That's case one.
This is literally case 1 on the agenda.
11:22.
Okay. All right, in OPS case number 2025-0086, Part B, for Officer Jones Parks, badge number 1598, regarding allegation A for unprofessional behavior / conduct, an alleged violation of Manual Rule 5.01, I move for a finding of sustained. As the preponderance of the evidence, including interviews, written reports, and cell phone data, as well as WCS footage, supports that the alleged conduct did occur, was inconsistent with division standards and violated Manual Rule 5.01, specifically that Officer Jones Parks was in improper communication with the complainant on his personal cell phone device under the guise of business activities, but eventually pivoted those conversations to non-business discussions in both voice calls as well as inappropriate text messages. So again, my motion is for a sustained finding for allegation A.
Second the motion.
Seconded by Member Willis. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. We need to group level these separately. Okay. Now in discussion for group level, what was IA's disciplinary recommendation on their side of
They
things?
don't do group levels.
They just did a straight discipline. What did they do?
They haven't done,
They haven't done anything to wait on us.
yeah, they have to wait on us.
Any thoughts? What you guys think as far as group level?
Personally, this is a cancer. We need to fire him. In my opinion.
Group level 3.
There you go. Termination,
I'm looking for the specific language for something under group level 3. I'm sure we'll find it, but I just want to make sure I have something. Engaging in sexual activities while on duty. Well, I don't know where these. That might come with one of the later sustained violations.
Because this one.
Because I don't know that were the communications specifically sexual in nature?
No,
Right.
no, they were inappropriate, but they were not
Yeah.
vulgar.
We have.
What about misuse of company time? But that wouldn't be under 3 though.
My rationale
We have
is,
dereliction of duty.
so am
Go
I
ahead.
tied to just, cause I'm looking at all of this as a group thing.
Right. Which
I'm saying you
yeah.
should.
Well,
This-
you can take into account the entirety of what happened here. That I think that's fine.
But I think I don't want us to over group it, if that's not even a term, but I don't want us to over group it, and let's just take them one by one. I think we get to where you think we should go just based on later things, but let's not overgroup the one to try to get there preemptively.
Understandable.
Because I'm thinking this should be misuse of company time. I think dereliction of duty would apply, but would it be that egregious? Because group 3, you really in termination range.
Right, and again,
This
my
first
mindset
allegation, I don't know if that
was
gets you there.
Well, but the first,
the collection of all of this.
But that's what I'm saying.
Right.
I think you'll get to where you want to go
Okay.
by the time we get to the end. But I think on this particular group level, I don't think you can hang them for that.
Right.
Okay. I move that this be classified as a group 3 violation for gross misuse of company time, as well as dereliction of duty, as well as conduct unbecoming and conduct that diminishes the esteem of the division. Yeah, I'll leave it there for now, but yeah, we'll include those. I mean, I would argue gross immorality violations as well for using his position as an officer, particularly to kind of open the door for the conversation, just to kind of change directions and try to use it for personal gain. So some of those are enumerated specifically in the disciplinary guidance, some are not, but again, we are not bound specifically to the language in this disciplinary guidance, because there are other similar misconduct catch-alls. So with that, my motion is for a group level 3 violation. Seconded by Vice Chair Miller. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. All right, same case, 2025-0086 Part B. For, again, Officer Jones Parks, badge number 1598, regarding allegation B for harassment and off-duty conduct. I move for a finding of unfounded as the preponderance of the evidence, including WCS footage, interviews, and written reports, establishes that the alleged conduct did not occur, even though the officer did ride past the complainant's home. The complainant was not aware of that at the time, and so therefore, I move that we find that this does not rise to the level of harassment. So again, my motion is for unfounded for allegation B.
Second.
Seconded by Member Willis. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. Same case, 2025-0086 Part B. This is same officer, Jones Parks, badge number 1598. This is allegation C, improper procedure for failure to activate his WCS. I move for a finding of sustained as the preponderance of the evidence, including interviews and written reports, as well as collection of other data, supports that the alleged conduct did occur, was inconsistent with division standards, and violated GPO 4.06.04. Specifically, that during these calls that were allegedly business related to the complainant, the officer failed to activate his WCS, and therefore he's in violation of GPO 4.06.04.
Second that motion.
All right, a motion has been seconded by Member Moore. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. I move that this be considered a group level 1 violation for WCS improper usage. Seconded by Vice Chair Miller. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. Same case, 2025-0086 for Officer Jones Parks, badge number 1598. And this is for allegation D for improper procedure, personal cell phone use, and alleged violation of GPO 4.06.12. Move for a finding of sustained as the preponderance of the evidence, including interviews, WCS footage, interviews, written reports, and cell phone data collected, all supports that the alleged conduct did occur, was inconsistent with division standards, and violated GPO 4.06.12. Specifically, Officer Jones Parks was viewing pornography during his, no, sorry, that's not this one.
Yeah.
No, he was using he used his personal cell phone to allegedly conduct business affairs during his work shift. So sorry. So just to be clear, again, this is allegation D, improper procedure for personal cellular phone use for using his personal phone, to allegedly conduct business during work hours.
Second the motion.
Seconded by Member Moore. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. All right. This is
one.
This could be a group one. I mean, I guess this could really fall under any of them.
Yeah.
Yeah, I'm gonna move for a group level 2 violation for conduct unbecoming, as well as unauthorized use or access to unauthorized use of his personal phone for business conduct, particularly because he used his phone in this case to allegedly try to conduct business when that seemingly was not his ultimate goal, and ultimately use it to disparage both his position and the esteem of the division as a whole. So again, my motion is for a group level 2 violation for allegation D.
Second.
Seconded by Member Parker III. All those in favor say aye.
Aye.
Any opposed? Any abstentions? That motion carries. All right, same case, 2025-0086, Part B. Same officer, Jones Parks, badge number 1589. This is for allegation E, for unprofessional behavior / conduct. I move for a finding of sustained as the preponderance of the evidence, including interviews, WCS footage, written reports, and other evidence collected, supports that the alleged conduct did occur, was inconsistent with division standards, and violated manual rules 2.14 and 5.01, as well as civil rule 9.01. Specifically, similar to allegation A, Officer Jones Parks was in inappropriate communication with a civilian, different from the complainant, so different from the complainant, but was inappropriate nonetheless with another civilian, and used his position to communicate with them, and then inappropriately changed the nature of that communication into a personal interest. So again, my motion is for a sustained finding.
Second.
Seconded by Member Sharp. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. All right, I am going to move for this to be a group 3 violation, similar to allegation A, for dereliction of duty, and diminishing the esteem of the division, and as well as other similar misconduct to the other group 3 violations listed under the disciplinary matrix.
I will second that group level.
Seconded by Member Sharp. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. All right, same case, 2025-0086, Part B. For Officer Jones Parks, badge number 1598. For this is allegation F, which is for improper procedure, failure to activate WCS, particularly during the phone calls that were mentioned in allegation E, that were made to a civilian during work hours, and allegedly related to an investigation of some sort or other business that was allegedly being conducted. And so, again, this is in alleged violation of GPO 4.06.04. I move for a finding of sustained as the preponderance of the evidence, including interviews, written reports, and cell phone data, supports that the alleged conduct did occur, was inconsistent with division standards, and violated GPO 4.06.04. Seconded by Member Willis. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. All right, 2025-0086, Part B.
You needed a group level.
Move for a group level 1 for WCS violation.
Second.
Seconded by Member Moore. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. Thank you. Okay, 2025-0086, Part B. Officer Jones Parks, badge number 1598, allegation G for improper procedure, personal cell phone use. An alleged violation of GPO 4.06.12. I move for a finding of sustained as the preponderance of the evidence, including interviews, WCS footage, written reports, and cell phone data, supports that the alleged conduct did occur, was inconsistent with division standards, and violated the aforementioned GPO. Specifically, that in the course of the officer reaching out to this second civilian that we've mentioned in allegations E and F, that he did so using his personal device, even though this was supposed to be for some sort of interview or business purpose. And so therefore it was an improper use of his cell phone device, of his cellular device. And so again, my motion is for a sustained finding under allegation G.
Second.
Seconded by Member Moore. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. To be consistent with the earlier group level violation, I move that this be considered a group level 2 violation for conduct unbecoming improper use of cell phone and electronic devices, as well as conduct diminishing the esteem of the division.
Second motion.
Seconded by Member Moore. All those in favor say aye.
Aye.
Aye. Any opposed? Any abstention? That motion carries. All right, same case 2025-0086, Part B. Allegation, this is the same officer, Jones Parks, badge number 1598. Allegation H of unprofessional behavior, unprofessional conduct, and alleged violation of Manual Rule 2.14 and Civil Rule 9.10. I move for a finding of sustained as the preponderance of the evidence, including interviews, WCS footage, and written reports, as well as cell phone data, supports that the alleged conduct did occur, was inconsistent with division standards, and violated the aforementioned GPOs. Specifically, it was found that Officer Jones Parks was observing pornography on his phone on his personal cell phone during his shift. And so again, my motion is for a sustained finding.
Second.
Seconded by Vice Chair Miller. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. I move for a group level. I just saw it. Group level. Okay. Yeah, I move for group level 3 for engaging in sexual activities while on duty, as well as dereliction of duty and conduct unbecoming of an officer, as well as conduct that diminishes the esteem of the division. So again, it's a group level 3 violation.
Second.
Say gross, as well as gross immorality violations.
You got to say.
Second.
Seconded by Member Moore. All those in favor say aye.
Aye.
Aye. Any opposed? Any abstentions? That motion carries. All right, same case, 2025-0086. Same officer, Jones Parks, badge number 1598. It's for allegation I of unprofessional behavior. conduct for making a false statement in violation of Manual Rule 3.12. I move for a finding of sustained. As,
I jumped the gun.
No.
Are you about to continue?
Yeah, move for a finding of sustained as a preponderance of the evidence establishes that the alleged conduct did occur. The products of the evidence, including interviews, WCS footage, written reports, and cell phone records, supports that the alleged conduct did occur, was inconsistent with division standards, and violated the aforementioned Manual Rule 3.12. Specifically, it was found that Officer Jones Parks stated during his interview, during his pre-disciplinary interview, that he had contacted no one else in a similar fashion for which he had in which he had contacted the complainant, and yet it was found that he had contacted another civilian, as we've mentioned in some of our previous allegations, with similar discussions and having similarly inappropriate conversations. So again, this is a motion to sustain the allegation for making a false statement.
Second.
All right, seconded by Vice Chair Miller. All those in favor say aye. Aye. Any opposed? Any abstention? That motion carries. All right, I move that this be considered a Group 3 violation for dishonesty, for false statements, untruthfulness, as well, particularly during disciplinary procedures.
Second.
Seconded by Member Moore. All those in favor say aye. Aye. Any opposed? Any abstention? That motion carries. I will also move that that this board strongly recommends to the chief that they consider termination for Officer Jones Parks as part of under Group 3 violation, given the collection of violations that occurred here. Yeah, I'll kind of leave it at there. But I did want us to make the recommendation that the chief strongly consider termination.
I have a issue and a question.
Okay.
Because of
Hold on, actually, first, can I get a second?
Second.
Okay, second by Member Moore. Go ahead, discussion.
Because of 115, I believe it's not in the chief's hands that would ultimately lie with us.
We can put it in the chief's hands if we want to, or we can. To be fair, we can impose termination if we want to. It has not been our.
That's not.
We've done it once before. So we absolutely can under Charter 115. We can impose the discipline. Generally speaking, we have only imposed group levels, and we have allowed for the chief to make the determination that they would like to make within that group level. Doesn't mean that we have to. So I agree with you. If the board wants to impose termination, then we can do that.
I'm just curious as to what would your rationale be for not imposing?
I don't have one. It's less about not necessarily wanting to terminate the officer and more about just sticking to the process that we've already done, which is allow the chief to make the ultimate decision. But we don't have to.
And that's my issue on that, is that we had a case earlier where we have allowed ourselves to be governed by past practices, where I don't want us, the term that I have the issue with was you said we recommend strongly. We don't have to recommend, we can impose. So I think if you wanted to leave this particular decision up to the chief, I think the wording needs to reflect that we as a board are leaving this decision up to the chief. So that is to say, if the chief does something less than what we would do, we then can't go back and say, no, we want to terminate, or you should have terminated. That's what I'm saying. So I think in the language that you put it, I definitely would take recommend out and say, we give the chief in this particular case, whatever, carte blanche to do whatever.
Okay. I have a question for Dahlia about if we are going to impose discipline, do we need to attach it to a specific allegation Or can we say, given the totality of the allegations here, we are imposing the discipline of termination? I would, my instinct tells me that we need to attach it to a specific allegation. We have already ruled on all of our allegations, which is why, but again, that was because my intention was to make kind of an overall, hey, chief, look at all this, and one of these group threes that we have, make that a terminable offense. But that doesn't mean we can't go back and change it, but.
I'm not sure, but based on everything that we've done before, if this should be attached to a specific allegation.
So, then is there the opportunity to amend this motion? Because if the motion goes for the way it stands, I would be inclined to vote against it. Because again, I don't believe that responsibility lies with the chief. Now, I agree with you, we can give it to the chief, but based on the way that this motion is structured, it says recommend.
Right, yes. Currently, the way the motion is structured, we could give it to the chief and the chief could decide not to terminate based on the motion.
And the other problem that we have, because what you just argued, we haven't listed that particular requirement with specific allegations. The chief could say, well, you only said this one allegation. On this one allegation, I don't think termination is appropriate. And all the other ones you said, you see what I'm saying?
Well, the difference is under my current motion, right? If we are strongly recommending to the chief that they consider termination here, I think we can make that as a blanket statement about these allegations because we're not imposing anything. The chief will be the one who attaches it to specific allegations. But if we are going to actually impose the discipline of termination, then we would need to go back and make a couple motions on some of the group threes that we had and amend it to include that we want to impose the discipline of termination. Does that make sense?
Yeah, so I think
Which we can do.
what normally would happen is that we would just make the group level, let the chief then make her decision, and then we say what our final discipline is. Because that way now we've considered now what the chief's point of view is on it. We have our own, and now this is what the discipline is going to be.
Yeah. I think that if we are in the mindset that we want to terminate, I think we should just do it now, because otherwise it would feel like we're changing, even though group three termination is within group three. I think it would be inconsistent with how we have done things to change the chief's decision if it's not a departure from us. Because, for instance, if we move forward with the group threes that we already have put forward, right? And then we make this recommendation that the chief terminates the officer, but the chief ultimately chooses not to, but does impose group level 3 violations as far as the discipline, then technically the chief's not departing from us. We'd be departing from the chief, even though the chief had agreed with us before.
Well, but I always thought we had the ability, not always, but under 115, we have the ability to, if the chief makes a decision and we don't believe it's adequate, that we can go above. We just can't go under.
I think the problem would be us changing the discipline. And I just think it gets a little gray.
So, I mean, then I agree with you. Then we should, if that's it, then we should clearly state to a specific allegation, our intent is to terminate. I think we should do that.
I think that if the board absolutely wants to terminate and wants to impose termination, let's just do it now instead of waiting to see what the chief says and then imposing it later. If we ultimately are like, we want to impose termination, then we need to do it now as opposed to waiting for the chief. If we want to say, hey, we don't know if we want to know what the chief thinks, then that's different. Then maybe we kind of wait for the chief. But if the board is very adamant now that like, hey, this guy needs to be gone, then we can do that. You guys have
Just a point of clarification. You guys are mentioning the chief. These, because they were group 3, these are going directly to the safety director.
Okay.
The one who terminated. Probably the strongest termination is the making false statements, which is specified in the charter.
Oh, yeah.
False statements you're presumed to be
Yeah, no, I totally agree. Which is actually the last one that we went over just now.
That's the one that we actually in the middle of voting on now. So then I would say then this this motion needs to be either amended, again, taking the.
Well, this motion isn't on that. We already did that. We still have to go back and attach it to this. This one we already did. It's a group 3. But we already did this one. This is a separate motion.
Can I interject? I understand we have to do things procedurally, but, and I hate to put more on our plate to think about, but from this specific officer, I think we're all in the mindset from being in this meeting that looking at the body of his wreckage of work, I think we're all coming to the conclusion of termination. However, procedurally and legally, we have to attach it to one thing. Should we kind of relook at that to?
Yeah, no. So I think that it could certainly, even if we attached it to one allegation, right, or we went back through all the group 3s and attached it to all of them, I think we can certainly, as an aggravating factor, that the totality of what is happening elevates even this one allegation. Does that make sense? So we can use the context of everything else as an aggravating factor, basically, to say that, like, hey, we know if you just looked at this in a vacuum, maybe this doesn't look like termination, but you add the allocating factors, it is. To Senior Investigator Boker's point, dishonesty as a charge is absolutely a terminable offense by itself with nothing else attached to it. And there are like multiple places that defend that. So
go ahead.
I was just gonna say, so just as a reminder, the current motion is to make a strong recommendation to the chief. If we do not want to do that, if we want to actually impose termination, then we should vote down the current motion.
Okay, so it's already been seconded.
It has already been seconded.
Right.
Okay.
So if we do not want to recommend, if we want to actually impose the termination, we should vote down this motion
Correct.
and then make another motion.
Okay. All right.
Everybody got that?
Yep.
Okay.
Go ahead.
All those in favor of making the recommendation? All opposed? Any abstentions? Okay, that motion fails. Okay, so now I will make another motion that for allegation I, unprofessional behavior or conduct for a false statement under Manual Rule 3.12. I move to amend our group level finding of a group level 3 to include that we are moving to impose termination as the ultimate discipline on this particular allegation based on the charge of dishonesty, as well as the aggravating factors looking at the wreckage of work, as my colleague put it, of this officer. When you look at the totality of his behavior on multiple instances, just being completely inappropriate, as well as diminishing the esteem of the division. So again, this motion is to impose termination as it relates to allegation I.
I second that motion.
Seconded by Member Moore. Those in favor say aye. Any opposed? Any abstentions? That motion carries. Dahlia, do you think that we should go through the other group level 3s and also do that again? I don't feel like we have to. I think. Okay, I don't think I want to. Do board members want to? Do you guys want to go back through the other group level? It's not a ton of them. I think there were 2 other group level 3s that we had.
I mean, you can to the extra.
Right.
Say, because you just use the aggravating factors for this one.
Yeah.
You don't.
Yeah, I feel like the record is pretty clear about what we want.
And I would say, just for purposes of the record, the this last allegation, an officer that would perjure him or herself having offended the manuals, I think no other greater reason to recommend termination than that. So I think in that the board has made the right decision.
Also, I want to, as I've talked to you about this, Brandon, as well, is that, and for police officers, like dishonesty comes to that presumption of termination, right? So it attaches best to that allegation.
Yep. Okay. So with that, you guys thought we were done. We're actually still not done with this case. Case 2025-0086.
Oh yeah.
Part B. And this is for Lieutenant Oliver, badge number 8586, regarding allegation J, lack of service, insufficient service, and alleged violation of GPO 1.07.05. I move for a finding of exonerated as the preponderance of the evidence, including interviews, WCS footage, and written reports, supports that the alleged conduct did occur, in that the officer did not necessarily follow up with the complainant about the complaint that she made to him. However, the conduct was carried out in alignment with the standards outlined in the relevant GPL, because the officer did forward that complaint to internal affairs to start this entire process. So again, the motion on the floor is for exonerated for allegation J related to Lieutenant Oliver.
Second.
Seconded by Vice Chair Miller. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. Okay, we are now at 12:08. We need to break for, we need a break, first of all. And then we need to go into executive session, and we need our time for executive session. So as much as I don't like to do this, we are going to need to table these cases. We may have a special meeting for today. I see that we got somebody else in the room. There's nobody who's here for a case, right? Okay. So we may need to table these cases. Well, we're going to need to table these cases. We may have a special meeting in order to try to clear these cases out. But we got to table it, because even after we come out of executive session, I don't think we're going to have time to get to this.
So, Chair, for if you have to have a special meeting, I will, for the purposes of quorum, make myself available.
Yeah. Okay. We can discuss. Yeah, we can discuss when we might be available for a meeting later this month. We can discuss that at the end of our meeting today. But for now, I'm going to move that we table the remaining cases on our agenda that have not been covered today. I'm not gonna list them out, but they're on the agenda. Do you want me to list them? Please?
Yeah.
Okay, I move that we table case number 2025-0182, case number 2024-0072, case number 2024-0170, case number 2024-0185, case number 2024-0197, case number 2023-0012, case number 2024-0052, case number 2025-0123, case number 2026-0063, case number 2023-0085, case number 2023-0101, case 2024-0283, case 2023-0229, case 2024-0266, case 2025-0014, case 2025-0035, case 2025-0037, and case 2025-0039. I think I got them all. I know I skipped one that we covered already, that we did actually get to. Okay, so I'll move that we table that list of cases. until our next meeting, whether that be a special meeting or our full meeting. Can I get a second?
Second motion.
Seconded by member Moore. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. All right. We are gonna take a break until 12:30, but
Sure.
before we,
Chair, we had two administrative subpoenas that do you want to table those or?
no, those are under new business afterward.
Yeah,
We can do it. We can do it.
one is for case 2026-123. It's a subpoena to obtain footage from the Cleveland Guardians Progressive Field. And the other is 2026-0125 to get footage from Jack's Casino. These are pursuant to investigations we currently have pending concerning allegation of off-duty officers.
Okay, I move that we issue a subpoena upon Progressive Field as listed in the subpoena that's being given to us today in regards to our investigation into OPS case number 2026-0123.
Second.
Seconded by member Sharp. Those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. All right, I move that we issue a subpoena to Jack's Casino downtown for as detailed in the subpoenas that were given to us today as it relates to OPS case number 2026-0125. Seconded by Vice Chair Miller. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. Okay. Okay, some of this stuff on new business and old business we will get to. So that's one of the reasons why I want us to break, so we can make sure we have time to get to the other stuff. We just won't get to the cases. Okay, but before we break, I'm gonna make the motion for us to go into executive session, so that way we'll break and then come back and we'll already be in executive session. So with that, I'll move for an executive session for personnel, employment, and discipline matters to be considered, and that we allow in, of course, our board members, our legal counsel from the law department. Do I need specific names? It was okay if I just named the department in that way. Okay. The law department, as well as representatives from the human resources department from the city of Cleveland, as well as our OPS administrator, Jeff Winninger, and our OPS general manager, Jessica Watson. Is there anybody I'm forgetting? Okay. Jeff, Jessica, anybody else that we need? I don't think so. Okay. So we'll leave the motion there. Can I get a second?
Second.
Seconded by Vice Chair Miller. We will do a roll call vote. Brandon Brown, aye. Shanoa Miller.
Aye.
Billy Sharp.
Aye.
Dave Gatton.
Aye.
Waverly Willis.
Aye.
Ed Moore.
Aye.
Glenn Parker.
Aye.
All right, that motion carries. So we will now enter into executive session. Thank you.
You can tell he is.
Okay, thank you everyone for your patience. I thought we'd be back at 2:15, 2:51. It's like 2:15, but like not. Okay. So first we have some personnel matters to handle. The first is going to involve an LR3 that we sent out involving employee with employee ID 2013853. Said employee was arrested and charged with criminal violations. An initial PDH was, that arrest occurred back in March of 2025. An initial PDH was scheduled in March of 2025, but the board elected to wait to reconvene that PDH until the criminal charges were fully adjudicated in court. Once we reconvened in May of 2026, the veracity of the employee's statements in the underlying criminal case and the subsequent disciplinary process came into question. Through the investigation and disciplinary process, it was determined that this employee violated civil service rules rule 9.10, as well as HR policies, including criminally charged employees policy and progressive discipline policy, because the employee was supposed to report their arrest to management and did not. They pled no contest to the underlying charges. An investigation of witnesses and other evidence uncovered inconsistencies in the employee's statements that they made during our pre-disciplinary process. Based on these facts, my motion is to sustain the charges that are stated in the amended LR3 that was sent to employee 2013853 on August 7th, 2026, with the note that the original LR3 was sent back on March 20th of 2025. Specifically, I move that the board finds that employee 2013853 acted unprofessionally when they presented police identification to an officer with the intent to deceive said officer during a traffic stop. The board further finds that the employee failed to inform a supervisor or the board of their subsequent arrest in a timely fashion as required by city policy. Finally, I move that the board finds that in the course of this pre-disciplinary process, the employee displayed multiple instances of dishonesty, including explanations for why they maintained the UHPD identification after separating from the department, the process for which they turned in the items to the UHPD at the time of their separation, and their rationale for presenting said identification to the officer during the March 15, 2025 traffic stop. Full and further rationale, as well as specific findings by the board, will be enumerated in a findings letter that will be sent to the employee subsequent to this meeting. But for now, my motion again is to sustain the charges stated amended LR3 sent August 7th, 2026.
Second.
Then seconded by member Sharp. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. All right. With that, I move that in consideration of the progressive discipline policy and in light of the previously stated findings, I move that the board terminate employee 2013853 from their current position. Specifically, given the level of damage to the public trust in the office that this misconduct had the potential to cause, the degree of responsibility inherent to the position itself, as well as the fact that during the disciplinary process, the employee's honesty and veracity were brought into question. The board finds that it is necessary and appropriate to protect the integrity of the office that we terminate the employee from their position. So again, my motion is to terminate employee 2013853 from their current position.
Second.
Seconded by member Sharp. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. Okay. Changing speeds a little bit. Obviously, that's tough, man. So there are a few other things that we need to handle as far as old business and new business. No, I'll keep skipping this, and I don't want to keep just skipping it, but for now, we'll skip over the OPS status report. If we got some time at the end, we'll go back to it. Actually, no. Let's do the OPS status report. Let's run through it. Jessica.
Okay, in June of 2026, we had 28 new complaints. We had 1 total administrative dismissal. In July of 2026, we had 32 new complaints. We had 3 total administrative dismissals. Staff-wise, we posted 2 investigator positions in July, and we had 2 new employees start in June. That's all.
Okay. So I know under new business, we have we're hiring for those 2 new positions, right? The 2 new investigators. Okay, good. All right. So under old business, we have OPS staff matters. What I'm going to include here, I don't know if this is really old business or new business, but I do want to kind of renew our delegation of duties to our administrator. So this is something that we've done in the past, mostly of practicality, because as a part-time board, we don't really have the ability to manage the Office of Professional Standards on a day-to-day basis, right? And so there's a lot of things that we would like for our administrator to be able to handle, and that's part of the call of the position. So with that, I move to delegate the duties of the CPRB to supervise the Office of Professional Standards, including personnel and disciplinary actions, to the current OPS administrator, Jeff Winninger.
Second that motion.
Seconded by Member Moore. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. For clarity, that doesn't mean that the board doesn't have the ability to, step in when necessary, or, change this delegation. But this is clear. Well, this is most efficient for, I think, everybody involved, and I think it'll work out. Okay. All right. OPS investigators. We have 2 positions. And we have 2 positions that are open, and we were sent 3 finalists. Is that right? Let me see if I can pull up there. When did you send that? Teams? Oh. Excellent. Okay. Okay. So assuming, well, not assuming, but understanding that the board has reviewed the top 2 choices, the 3 that were sent to us from our general manager and our administrator, I'm going to do these separately to make sure that we're doing the motions right. I move that we hire person ID 606-42702 for the position of investigator. Can I get a second?
Second.
Seconded by Vice Chair Miller. Is there discussion? Does anybody have one?
I'm looking for those identifiers. I'm sorry.
Okay.
It's not in our packet, is it?
Not that was printed, no.
Okay.
It was emailed to us. I'm gonna move forward with the vote for the sake of time, but if you want to abstain, feel free. Okay, a motion has been moved and properly seconded. All those in favor say aye. Aye.
Aye.
Any opposed? Any abstentions? That motion carries. All right, I also move that we hire person ID 392-79294 also for the position of investigator.
Second that motion.
Seconded by member Moore. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. All right, couple more job posting related things. I move that we authorize the Office of Professional Standards to post a position or post a requisition for the position of senior investigator and for executive coordinator. Seconded by member Gatton. All in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. Okay, we've already covered the subpoenas. Is there anything else you guys need from us? Okay. Now open public comment. Again, at the end of our meeting, it appears that there is no one here for public comment. So seeing none, I will now close public comment. Is there anything else we need to do?
No, so we wanna figure out when your next meeting is gonna be, we're doing a special meeting.
Yeah, it's automatic. We don't make a motion to come out. We just come out because we can't make motions in this session. So, okay. So the week of the 24th. What about Tuesday or Wednesday?
Wednesday.
You can do Wednesday. How about Wednesday? Let's go see about Wednesday the 26th. This will probably be a longer meeting. This won't be one of those like 5-minute meetings. This will be like probably 2 or 3 hours because we got to get through these cases. Well, that would be the purpose, is to get through these cases. So I would carve out 3 hours, maybe like a 9 to 12.
26 works for me.
Okay. Good. Glenn.
26.
Okay. No for you. Wave.
It's
like a
virtual meeting.
This would be virtual. We'd make it virtual. I'm thinking like a 9 to 12 to get out the way early.
Yeah.
Okay, so that's Wave. You said that works for you. So 1, 2, 3, 4, 5. We get Diana. That'd be sad. I'd like to have 6 just in case something happens with somebody. Although quorum right now is half plus 1, so it's still 5.
I'll say the 26th. As of right now, there's something scheduled, but it may not happen. I'm better in the afternoon.
Okay.
We'll see.
So we'll set it for a special meeting for August 26th at 9 a.m. It'll be virtual. We'll be going over the cases that we tabled today. If for whatever reason any of you, besides member Parker III, who's made it clear that he was not available, if any of you for whatever reason turns out that you're not going to be available, please let me know as soon as possible. Right now we have 5.5 commitments. Speak with Diana as well to see if she may be available. She may or may not. But yeah, if we only have, we'll see. Because anything can happen. So.
Oh yeah. By the way, we got a seat that needs to be filled. What is the time? That may be the.
I doubt that the seat will be filled by then. And we'd be looking to try to onboard. We do have a vacancy.
And
So is it-
application put it, yes.
Okay. Is it still open or is it closed?
No, it is not.
Okay.
It's still open.
Okay. Well, I would encourage people, if anybody's listening, if anybody's out there, if anybody's listening, I would encourage you to apply if you feel so inclined.
Did you
Yes.
I did. It's been a meeting, man. If you guys can't tell, my head is fried right now. So I would encourage people to apply. There was something else I was going to say with that.
District, right?
It has to be someone from the 3rd district. So if there's anybody in the 3rd district, which I believe is like the downtownish area, pushing towards the east side, I think it has a little bit of west side too, actually. But yeah, you can look up the 3rd. This is for the 3rd police district, not the 3rd ward, the 3rd police district. So yeah, we're looking for some people. And yeah, well, I think that's it. So hopefully we'll be able to move forward with our meeting on the 26th. Is there anything else for the good of the order? Anything else anybody need from us? All right, guys, I appreciate you. This has been a weird meeting. But we made it through and here we are. And we look forward to continuing to push forward and doing the work of the city, doing the work of the people. So with that, I will entertain a motion to adjourn.
Motion to adjourn.
Second.
Properly second.
Okay, it's been properly seconded. All those in favor say aye.
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 Any opposed?
Jumping the gun there.
Any abstentions? That motion carries. Yeah, Vice Chair.
That's right.
I'm not.